Yes.
Serial number 48. For the appellant.
Serial number 48.
48. Mike.
What do you want? Time.
48. Time.
The second week of April.
I'm making a mention, my lords, for a listing. We are, my lords, the contractual employees who are working for last 23 years. We have succeeded before the learned single judge. Government is in appeal. Now, my lords, most of us, my lord, about 70 of them have retired from service. The remaining, my lords, are due for retirement. Therefore, my lord, I have also filed a contempt and government has filed an appeal. Both are listed, my lord. Both are connected and notice is issued.
Then why you are in hurry?
Because all of us are retiring without even pensionary benefits, my lord.
You have succeeded, we will learn a single.
Please, my lord, we have succeeded before the learned single judge. Contempt is pending, but of course, writ appeal also they have filed. Therefore, my lord, I can't even press the contempt. And now, my lords, we are retiring without even pensionary benefits. Some of them have actually retired.
It will be posted. Wait for some. They will move the court in their own appeal. Then we'll see.
My lords, but I am retiring now, my lords, without even pensionary benefits.
Simply the matter of time. If you are going to succeed, is a matter of time. Wait
Very
for
well.
a week or so. Then again mention if need be.
Very well.
This is the content,
Great.
my lord. Previously, my lord said all the minor child for an in-chamber proceedings with the former Chief Justice. The interim arrangement had been challenged before the Supreme Court. This is pertaining to the two doctors. My lord had conducted an in-chamber proceeding. The father has tied the child
Next
inside
week.
home. My lord.
Next week.
Lordship's kind
One
permission.
writ appeal, my lords, writ appeal, where the learned single judge's order has overturned my entry in the revenue records and also ordered restoration of erstwhile owner whose name was seen 25 years back.
It can wait.
My lord,
Yes.
Contempt matters, my lord. Your lordship claim are two matters, my lord. Contempt matters where notice has been ordered, your lordship. Thereafterwards, my lord, it was not listed, your lordship. That's the reason, my lord, because rice mill run by the food farmer, my lord, has been seized after the interim order has been granted.
You want listing?
It is to be listed, your lordship.
Listed
Contempt
after 10 days. So it will be, why you are mentioning all of you? Once you remove the office of, it will be listed. Wait for 5-6 days. Next week.
fresh matter.
My lord.
PIL. It has not been listed since filing. Kindly.
It can wait.
My lords,
PIL
fresh
can
matter,
wait.
my lords. The
PIL
mining
can
matter,
wait.
mining matter, my lords.
It will be listed in due course.
Mining matter, my lords.
Within 15 days listed. All matters should be listed within 15 days. Don't mention.
Lordship's
My
kind
lords,
leave, my
mining
lord.
matter, my lords.
One contempt petition, my lord.
It will be listed within 15 days. You
But
give
similar
memo.
matters are coming up day
It
after.
will not be listed before 15 days. Those who mention, no listing before 15 days because the matters are going to be automatically listed once you remove the office objects.
May I make a submission?
All after 15 days.
The grave urgency is this, Lord, an open playground used by 30 to 35 schools has been encroached upon, Lord.
Encroachment.
Grave urgency. The open playground, Lord.
Not before 15 days.
Kindly, Lord.
May I make a
Property will be
submission, my lords?
wasted, they are making
Nothing, no urgency. Yes,
short date maybe, Lord.
sorry. All will be listed, all matters where you are submitting memo will be listed after 15 days.
My lords, the urgency is this, my lords. The auction is on 20th, my lords. Mining matter, my lords. The petitioner is having an agricultural property and an iron ore has been dumped on my property. Now auction is being scheduled on 20th. My lords, if the respondents conduct the auction, my lords, the
See that if
prospective
the
bidder
office
will come
objections
to
are
my
removed,
property and he will remove all the
all may be
vegetation, my
listed
lords.
within the span of 10 to 15 days. After it will list. Yes.
My lords, the auction is on 20th, my lords. May I request for tomorrow, my lords?
Lord, yeah, it's very urgent regarding Salem, Lord. Millards, in one matter, there is Ramzan food mela is being conducted in Desert on one of the Pulkesh Nagar constituencies there. Every Ramzan from past 8 days they are conducting food mela, Millards. Since Ramzan is going on, they have started erecting the temporary tents in the name of stalls, Milord. It's very urgent matter, Milord. We'll take it on tomorrow. Please.
How you are aggrieved if food is given to the poor people during Ramzan?
Lord, it is violating.
Next time.
May I
Yes.
request for tomorrow, the reason is 20th, the matter is, so there is this auction on 20th.
Auction,
Auction is on 20th.
all list. Two more.
Manoj, just seeking stay on the arbitral execution of the arbitral award. Manoj. And this week, any day can it can be.
After 10 days.
Work has been stopped. 40 labor are without work. There is urgency. We are subsequent hospital.
We have said that all after 2 weeks.
My lord, in this matter, my lord, the PIL, my lord, in view of the acute water shortage, my lord, in Bangalore, the PIL is in respect of that, my lord. Lord, the
Everybody is
PIL
working on overputting for overcoming the water shortage. Because VPL can wait.
The urgency is the water shortage, my lord, there's no drinking water in the city. Therefore, my lord, may kindly have it tomorrow.
After 15 days.
The PIL filed not to close the Kerpuram railway underpass.
We have said that all matters will be listed after 15 days, not before that.
Of 15 days.
You are all of you are at yes.
Writ appeal of the year 2023 for preliminary hearing. All prosecution proceedings are stalled in view of the writ appeal filed by the employer. Urgency is, my lord, 81 workmen are suffering. Whatever date convenient.
Yes.
My lord, a matter for mentioning, my lord. But serial number 34, my lord. I appear for the respondent. My lord, may please have it after 2 weeks. I've informed the appellant.
My lords, I appear for the appellant, my lord. We have no objection. My lord, the date may fix next week, please, my
Yes.
lord. In this.
2 weeks.
Grateful.
If I may make a mention with regard to serial number 16.
Obliged.
I'm for the complainant number 2, my lords. Seeking 2 weeks' time, my lords. There's some development as per the Supreme Court's order, my lords. We need to seek some instructions from the complainant also. For that reason, my lords, seeking 2 weeks' time, my lords.
Where is complaint?
Number one.
We have informed the accused. my
They have
lord.
informed. Lordship, kindly fix the date, your lordship.
Indeed, my lords.
Because
After
3-4
2
days
weeks,
are
any
taken
date, my lords.
2 weeks, lordship, kindly fix the date.
At the joint request of learned agriculture parties, stand over to after 2 weeks, give some date. It may be 18th of April.
Lordship, will be, kindly in the first week of April, your lordship. But they have taken 3 to 4 dates already, your lordship.
No,
Maybe
my lords.
they have only requested.
On the
for
last
amendment,
occasion also, we had
Third or
argued
fourth,
since
your
there was a.
lordship.
What is the direction?
No, they have taken dates, your lordship.
It is contempt petition.
The contempt. It's a contempt.
What is the direction?
What is the direction in
What is the
the
direction?
order? The Supreme Court, your lordship, the administration has been handed over to government, your lordship. It's a matter pertaining to the administration. taking
18.
1 day. Third or fourth, your
Grateful.
lordship, may kindly. Third or fourth, your lordship.
Third and fourth is houseful.
First week, your lordships. He did be prior to that, your lordships, kindly. Because Supreme Court matter is coming on second, your lordships. Anyways, after second, your lordships may be taken up.
To that
That Murga Math case.
Chitradurga Math.
Yes, my lords. Indeed.
The urgency.
My lordship,
18th.
Grateful.
my lordship mentioning my lordship serial number 160, my lordship. Tata
60.
Company. Yes, my lordship.
Yes.
And for the petitioner, my lordship. Short accommodation.
Whenever you want. After 2 weeks.
After.
Your lordship, serial number 33, your lordship.
Interim order may be.
Interim order shall be extended.
Serial number 33, your lordship. Pray for a week's time.
So in all matters, give particular date. Send over to such and such at the request of so and so. Interim is granted. Yes.
Serial number 33, your lordship.
33. Yes. What
Pray
do
for
you
a week's time.
week's time. We'll grant 2 weeks.
Please, sir.
2 weeks. Yes.
My lords, in CCC 387 of 23, it's a contempt matter. I request you to post it on 21/3.
No. After 3 weeks.
After 3.
Yes.
TV, till number 1. Kantaraj B.
Time order. Office objection to be removed within 2 weeks, failing which the contempt petition shall stand dismissed without order of, without reference to or order of the court.
Is for third time, seal number 2.
The appellant, my lord.
Kalyan Basuraj.
I'll have it complied within a couple of weeks, my lord. The problem is I was not made a party in the proceedings before the learned single judge, so I don't have all the files which were there before the learned single judge. 2 weeks time may be granted, my lord. So I'll have it complied.
Or office objection.
Office objection.
Granted.
Obliged.
2 weeks.
So then do it within 2 weeks, and otherwise you automatically.
Certainly.
Seal number 3. Filled by government.
Appear for the appellant, my lord. I pray for 3 weeks' time, my lord.
3 weeks.
Yes,
3 weeks.
obliged.
Seal number 4.
I'm
Send
over
for
to give us 3 weeks, 19th of, 22nd of April. Color photographs, production of color photographs dispensed.
I'm petitioner, my lord. Serial number 4.
4.
Petitioner.
Which one? Third.
Already complied objections, my lord. Another 3 objections raised. The lordship may kindly see. Petitioner husband is undergoing to treatment of cancer. He was railway service, he was retired. This honorable court was passed orders on 27/2023 to give salary arrears of salary and retirement benefits. The respondent has not considered the final order of this honorable court, my lord. So he is undergoing treatment. Doctors directed the petitioner to provide treatment and by making operation, my lord. So notice may be kindly issued. Meanwhile, I comply the remaining office objections.
Some inquiry was to be undertaken for 40. Same?
He is suffering for cancer, my lord. Petitioner husband.
This is 4, sorry.
Notice may be kindly issued. Page number 45, my lord. Page number 45.
Page number? Page number?
45, please.
40.
This honorable court on 27/2023. In 48, heard the learned counsel appearing for the parties in the writ petition. The grievance of the petition is with regard to release of salary arrears and retirement benefits of her husband, G. Krishnamurthy, when he was working with the respondent 6. In this regard,
Having heard learned advocate Mr. Vidiga Rajgopal from a notice to the respondents returnable.
Notice me.
Third, within which time the respondents are expected to comply with the direction.
Operation must. He has undergone operation.
No, the compliance can be done by you only.
Please.
It is for compliance, not operation.
Only.
We will comply.
Notice may be given.
Yes, it is 23rd of April.
That's it.
For 5th time, seal number 5. Shemi Charity.
And for the appellant in this case, 2 days time may be granted, my lord. One
For the
objection is
KVA
left
to
out, my lord.
respondent, I have not been served a copy of the appeal
serve
memo,
it.
my lords.
No copy.
And also, my lords, the impugned order was passed by one of my lords. My lords have, impugned order has been.
Not to be placed. Not to be placed before the bench where one of us, into Brigadier Honorable Mr. Justice Nandis Dixit, Brigadier is a member.
I'm grateful for this.
For 7th time, seal number 6.
For the contesting respondent, one landowner, appellant in this matter, your lordship. Kindly pass over your lordship. Senior is already arguing a matter before court hall number 2, your lordship.
Pass over. Pass over.
Number 7. Rajesh Kumar.
Appearing for the government, my lord.
This is the
PPMP, my lord.
petition concerning the
Solid waste management.
solid waste management. My lord. On the last date, my lords was pleased to direct the 2 stakeholders, because this is a non-adversarial litigation. My lords was pleased to direct the BBMP and the Pollution Control Board to have a meeting to formulate how to implement the orders of my lords.
May I seek a accommodation of about until the conclusion of the code of conduct, my lords, for the meeting to be conducted.
Eleventh
My lord,
September.
because of the orders of this honorable court, While it's over a
12th
decade, my
September
lord,
2023
the
is the
directions of
order.
my lords have been helpful in streamlining the operations of the waste management in Bangalore.
Do you want time for the purpose of, why do you want time?
I'm sorry, my lord.
Why do you want time?
My lord, sir, BBMP has come out with a policy whereby there will be decentralization of all the processing units, my lord. So right now, what's been happening is all the dumping is happening at one landfill. But now there is a BBMP is lagging behind in the processing of all the waste that has been collected. Instead of having it at one place, BBMP proposes to acquire hundreds of acres on the borders of all Bangalore. A policy draft has been kept ready for this.
Don't pull it out.
No, wasteland that's there. It's the ongoing process. So it is 2010. So they moved also.
This is connected.
So you're in process of developing the waste management plants?
Yes, my lords, at all the four corners of Bangalore, because we would require hundreds of acres for each of those plots, wherein that plot would contain not just disposal, but also processing of all the waste that is collected, for which there will be a buffer zone which will be collected, which will prevent any odor and smell coming to any neighboring places. So is it the process of acquiring these?
So
Policy draft has been
continue to
kept
be-
ready. It is for the cabinet at this moment. my lord.
Continue to do it.
My lords,
Code of conduct will not hamper these things.
my lords, the policy which has to be approved by the cabinet is kept pending and that can.
That is pending from
so it is-
2000.
No, no, no. That's
Can I make
2012
one
is a-
submission,
Will
madam?
keep beyond after vacation.
grateful, my lords.
No, can I make one submission, madam? The connected matter
They
514.
are in fact alive to the, what you are.
Yes, yes, I'm not disputing that. I'm just raising this connected writ petition 51475 of 2019. This was, my lord, which may be relevant now for my lord's consideration, where the National Green Tribunal has already directed that quarries should not be used as a dumping ground for waste. Now, my lord, in Chennai, etc., what they're doing is they're using quarries, which is a natural water collection resource, rainwater collection resource, for the purposes of providing water to Chennai. Here, my lord, what they're doing is they are using these quarries, which can otherwise be used to providing farmers with water and for the animals. They're dumping waste.
In fact, we are given suggestions. This court asked suggestions from the petitioners. That also been furnished to the BBMP.
Therefore, there was
For them to act on
my
that.
lords was pleased to direct on the last date for a meeting between Pollution Control Board and the BBMP, because it's not adversarial.
So they are choking out some policy.
My lord,
to
that's
say-
completely different. They are every time, my lord, they go on a different direction. Therefore, my lord's intervention is requested. Here, my lord's decentralization is the norm. My lords was pleased to direct
They
on
are
the
saying that they are directionless because of the code of conduct.
waste management.
In fact,
This has been going on since last 12
Yes, yes.
years.
Only the
It's
meeting-
an ongoing process only.
Not disputed.
Not a
Only-
litigation, it is an agitation.
Yes, yes.
Therefore, wait.
Only that meeting, my lord, that's all I'm requesting.
So your espousing cause has been working.
Yes, Lord.
Yes, yes.
So wait, let it travel slowly.
I'm only requesting that meeting which they propose.
They are doing everything.
Yes. Please.
They will apprise us on
Yes.
the next date.
Yes.
also.
So some date may be given.
Date will be given, but after vacation. In this second week after reopening. In fact, it should go in the June.
3rd June.
First week of June.
Still number 8.
Lord, this is a state appeal.
Senior is not feeling good. 1 week time.
This is a state appeal, my lord. We had filed a memo stating that this issue is seized by the Honorable Supreme Court.
8.
The memo was filed on 9/1/2024, my lord, by the state, wherein the moot question is about when the employee was taken as a daily wage worker, and then after he is regularized, whether the period when he is a daily wage worker.
Connected matters are pending with the other bench now because
No,
of
my
the
lord.
amendment.
Yes.
Amendment.
Yes, this is not with regard to the amendment. This is with regard to whether the benefit of gratuity can be taken under the KCSR rule as well as the Payment of Gratuity Act. When he is appointed as a daily wage worker, my lord.
rules also provide for payment of gratuity. Payment of gratuity. Provide for payment of gratuity. But the gratuity payable under the act. Follow the service rules, they should follow the act.
Yes, daily wage workers employed initially and then regularized after a couple of years.
So after that.
My lord, my memo may be seen.
Regular afterwards, after 10 years, 15 years, they regularize it. Permanent employer, they said. Only thing is they is not paid
My lord,
date
he
of
is,
temporary.
we are not denying the gratuity. Now, once he becomes a public servant, as per upon regularization, then rule 248A comes into place. So here, what they are seeking is before regularization, whether-
Pre-regularization service should be counted.
as under the payment of gratuity. Now, that would not be possible because the definition employee states that if you are part of the central government or state government, then you cannot come under this act. So the issue would remain whether he can take the benefit of both the legislations, that is under the Payment of Gratuity Act as well as the KCSR rules. Because under the KCS, has been given.
Ancillary benefits, there are provisions in the KCSR to pay part of that service for ancillary, part of that. KCSR, there are such provisions. That's in service rates.
In fact, two points, my lord, if I may just put before your lordship.
There are rules, the KCSR, etc.
My lord,
So we let put down for final.
please, my lord, if your lordship just looks into the memo, this matter is seized by the Honorable Supreme Court and the memo was filed on 9/1/2024. The similar issue is seized before the Supreme Court and the moot question, if your lordship sees the order, my lord, the order is dated January 21st, 2020.
Is there any order by the apex court saying that similar pending matters shall not be touched as there was under section 24 of the 2013 Land Acquisition Act?
Please,
There is no
no,
such.
no, there's no such things, but it's just seized. So if the matter needs to be heard, it needs to be heard on merits. That's my only submission. And just to add, my lord, in 2014, upon the retirement of this employee, we have paid the gratuity amount as per the KCSR rules.
Post regularization.
Post regularization upon retirement, calculating as to how much he's entitled as a daily wage worker also, which has been specified. If we look into the KCSR rules, my lord, that is 248A. It looks into the aspect of daily wage also.
So something is pending before the Supreme Court. Very
This issue is pending before the Supreme Court, my lord.
Civil appeal is pending.
And that order I have placed by virtue of a memo for production. And in fact, there are various divergent views about this.
for the hearing. Since it is, something is pending before the Supreme Court. The council said that is directly same.
You are filing memo. Tomorrow filing.
We have seen the, so in the second week of June,
Please, my lord. Much obliged.
second week of June.
Tenth of June. Case number 9, Mr. A. Nagarajappa.
Appearing for appellant lordship, I kindly pray for a 2 weeks of time to comply the office objections raised lordship. Appearing for appellant lordship, I kindly pray for a 2 weeks of time.
3
To
weeks.
comply, 2
Three-
weeks.
2 weeks, 2 weeks. Yeah.
Much obliged.
Case number 10. Shrimati Amruta MV.
I appear for the complainant, your lordships. In the last occasion, the learned government advocate was referring to the grant is not there, but I strongly refute. And it was not an issue during writ petition proceedings. And also the order is not based on that particular issue. And the Honorable JMFC Tirthalli has mentioned in its particular order that the curator of the Keladi Museum
You have considered the representation and made the order. Which is that?
Additional affidavit dated March 27/10/2020. Two affidavit signed.
So you referring to
And two-
additional.
two affidavits of 50 pages have been filed.
Document dated 15/7/2023 as per annexure R.
Annexure R?
2. Page number 20.
You have only assured the action will be taken. Where is the action taken? Huh?
Since there is no title document that you can buy there.
Your lordships, the title document.
Question is, you were required to consider the representation. Not being engaged in interaction with each other. You should have said what all you wanted. Whether if they produce, you will pass an order. If they do not produce, then also you have to pass an order. You can't say, you have not produced anything, therefore I cannot pass the order. That's not the text of the direction. See the direction. There, your assurance is not accomplishment. The direction is for accomplishment. Consider the representative. Consideration has not happened.
My submission is, since the title documents are not there.
When did you ask them to produce title documents?
And in the earlier affidavit, we have clearly stated the previous.
Your lordships.
Which are your title documents on the basis of which you make claim for entry of the
Yes,
record?
your lordship. I will, the Honorable JMFC Tirthalli has mentioned in its order that the curator report of the Keladi Museum specifies the Shila Shasana, where from 1600 to 1687, the grant has been made to Balagaru Mutt.
The extent of grant land is not mentioned, but it is mentioned that it has been given to Balagarumat. And again, in 1405, the archaeological report of 71-72 report says that in the epigraphy, paragraph 24 says, King Veeranna Vadiyar has granted the land to Sulabhatirtha Swamiji of Balagarumat. It is very much there. And these two are vital documents. And apart from that, in 1873, the Pakka book record is there. And the mention, Diwan Purnaya has directed to continue levying of tax.
You are indicating in your replies only the process, not the decision.
Lord, we have filed two
All
affidavits.
these are vital documents
For
and
Lana
the legal
Singhal, you did
documents.
made a statement that you will be taking appropriate decision in this regard within a time-bound manner.
Please.
In that context, only the reduction is given.
No, in the earlier affidavit, we have stated, since the name of this particular mutt is not mutated in the revenue records, and also there are no title document to show that this very land has been granted to the mutt. We have issued an endorsement stating that blood, in these circumstances, they are no doubt in possession of that particular land.
Where is that endorsement?
Your original commissioner,
please
come to page 54.
Please.
Your original commissioner has said, this is not the government land and it belongs to the mutt. Please come to page 54.
Yes.
Translation is 50. On the basis of the deputy commissioner's report, the regional commissioner says it is not the government land at all, and mutt is in possession. Well, then why are you not mutating? He says that it is mutt's property. Again, you want an order for that purpose. If you say that it is not your property, and prima facie, you have found them into be possession, that is admitted.
Possession is admitted, there's no doubt. That is exactly for the reason. Under these in a peculiar circumstance of this case, the deputy commissioner considered the case of the mutt and sought clarification from principal secretary. That is what annexure R3 is.
Please read, in Kannada it is. Please read paragraph, in Kannada it is. Still, we request you, because your translation is not correct. Please read page 54.
Please.
Last paragraph.
ಒಟ್ಟಾರೆಯಾಗಿ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಶಿವಮೊಗ್ಗ ಇವರ ವರದಿಯಂತೆ ಬೀಳುವೆ ಗ್ರಾಮ ನಕಾಶೆಯಲ್ಲಿ ಬೆಳಗಾರು ಮಠ ಎಂದು ನಮೂದಿಸಿರುವ ಪ್ರದೇಶವು ಸರ್ಕಾರದ ಸ್ವತ್ತು ಆಗಿಲ್ಲದೆ ಇರುವುದು ಕಂಡು ಬರುತ್ತದೆ.
To admit name of the mutt figures
in the map.
In the map itself.
In the map, yes.
And it is your map.
Yes.
Map contains presumptive value under section 133 of the act. Still you don't want to act. And you say it is not our property. You say mutt's name figures there. One section. Every revenue record, including the nakashas, shall be presumed to be to incur. And it is the case that they are not the owners of the property. It is your case that you are not the owner of the property. And it is your case that mutt is in the possession of the property. Mutt's name figures in the revenue records. A map is a revenue record. It is held so by the division bench of this court.
The contention of the survey department is not in
Since
order.
1920, village map.
Conditions regarding mutation are satisfied. And mutation doesn't reflect in title.
Yes.
So this is how the matter stands.
When it comes to mutt, we will do all these things. We are sorry to say that there is such an observation in one judgment.
Your lordships, I may be permitted to read the list.
He is on. Please be seated.
Why don't you decide yes or no?
Yes.
I'll seek instructions on this.
No instruction. We want a decision.
Please.
Based on instruction.
Please. Raj may kindly have it next week. By that time, I'll come.
You said that 1, 2, 3, 4 are the reasons where the mutations are not required. You say that if you want to say that, but say something. Don't keep the things volatile.
Yeah, last may kindly peruse in the
You just go on discussing the process of consultation.
In the affidavit, they have taken a contention, Lord. That Lord,
This, Mr. You know, we need not say that this contempt is a mathematical thing.
yes,
Correction and comply with either way. Merits will not go, but you.
that's true.
That is the whole. You can't avoid the compliance.
In the light of Rule 72 of Karnataka Land Revenue Rules, Lord, we have extracted that also, Lord, which says after mutation entry only, Lord, this Podi and Durasti can be conducted. Because
Therefore, you have to make the entry. Without that, because your division been said, to which you have argued that matter, unless entries are made, one cannot ordinarily apply for durasti at all.
That's,
You have said that. We recorded it and disposed of that writ petition.
yes, yes.
Now, the case is for consideration of the representation to make the entries in terms of your records.
That
You
is,
do not want to do.
in the light of this, Lord, ADLR referred the matter to the DC. He has
To
considered.
make entry, rest of the things will fall at place if you make the entry first.
Please, I shall.
We do not understand the standard.
A week's time may be given. 2 weeks' time may be granted, Lord. I'll come back.
And don't say code of conduct is in operation.
For this,
No, it will not come.
not apply to judicial proceedings.
Yes, yes.
All right, 2 weeks, but
2 weeks.
do it within 2 weeks.
Date may be given. Date may be given.
Date we are giving date. 16th of April.
60.
Seal number 11.
There's a preliminary objection with respect to maintainability, my lords, which was raised as recorded by order dated 6th February. My lords would see that order for a minute.
Suit is still pending.
Suit is still pending, my lords, and even the contempt is still pending by both sides. Both sides have filed contempt.
It's an MFA order passed by this court. But injunction was granted in their, injunction order was granted in their favor. My lords, we approached this honorable court in an MFA. The order of this honorable court is at my lords, page 18. Both the parties shall not.
2A.
Lords,
have already
2A.
held that way.
Lords, I will only submit this. 2A was filed. Lords, that's for attachment. But my only thing is this order of injunction merges with the order of this honorable court.
Correct, on the civil side.
On
It
this
does not lose the character as an order being passed under 39 1 in 2.
Lords, I'm only saying.
So grateful,
It's only a case of attachment and it's a.
There is already there is a decision.
Lords, once there is a merger, my only thing was, my lords, 39-2A says passed by the court.
Correct.
If it is passed by the court, my lords, I understand, my lords, your lordships are saying
It is merged with
Muhammad Nuh
the
versus
court,
state
my
of
lords,
UP.
the court order of the.
But then it retains the character of injunction.
It treated. Now both the parties were directed not.
Fine distinction between injunction and the contempt.
Grateful, my
That's
lords.
the only.
Vis-a-vis contempt jurisdiction, there is a fine distinction.
I'm my lords, what I was trying to make out is the.
It is how the courts are holding that once 39-2A remedy is available, we will not entertain the contempt jurisdiction.
Same.
That's the only issue.
There's a division bench judgment of this court, my lords, which has been followed all over the country. Rudraya versus State of Karnataka.
Subsequently, we have filed a 2A application. That, my lords, is only for attachment. My only issue is there will be no punishment under 2A, my lords. It only provides for an attachment.
You are interested in punishment or compliance?
My lords, there's neither, my lords, what happens is it's only an attachment here. There is a,
That's
I leave it at that.
legislature in its wisdom said.
2A.
Seek the remedy for implementation. Can we give remedy more than what the legislative wisdom has provided for?
Lords, that is one of the, this doesn't bar, but I leave it at that. My lords, contempt is still available.
Some other.
That's what.
It may not.
So in order to avail the remedy.
It's, we have already, my lords, your lord, we have already filed it, my lords. So under 2A also application has been filed before the trial
Then
court.
we'll say that since learned senior counsel, Mr. Anindra fairly stated that The application under section, under order 39, rule 2 capital A of the code of
Has been subsequently been filed.
is already filed in respect of the order complained of in respect of the order brought under the contempt jurisdiction, and that the applicant shall pursue the said remedy, these contempt proceedings are disposed of accordingly, reserving liberty.
Words use this.
2A provides for detention.
Words, but the words, if your lordship
Detention
sees, the words used.
No.
No, court, the order
Proceedings are
passed by the
disposed of.
court is what is
Things are
essential.
disposed of. The court has not expressed any opinion on the matter.
Deeply grateful, my lords, deeply grateful.
Number 12. Mr. Swaroop, yes?
That's in serial number 12. That's 12.2 is a state appeal minutes.
State commissioned a project. They wanted a video recording to be done, to be exhibited at that industrial exhibition time. One fine day, just before this thing, it appears from the direction issued by the Honorable Minister, they say we are not satisfied with the video, therefore we don't pay.
Positive direction to release the balance of the amount.
Yes, my lord. None of these things are in dispute.
That's amount towards what?
This was amount is by way of what it is?
We have produced a video of 3 minutes exhibiting or rather showing the industrial development in Karnataka, which was to be.
So you prepared some documentaries for the state government.
Please.
Let's, I pay for the state. Let's 12.2. The state has also preferred an appeal, writ appeal, my lords, challenging the order of the learned single judge. Now the issue 12.2, my lords, is the 12.1 is this appeal, writ appeal preferred by the instrumentality, my lords, which awarded the contract.
Yes.
The respond number 2 and 3 matters have to be heard, my lords. We are ready, subject to my lords. In fact, in this matter, the adjudication, my lords, of damages is what arises. Now, assuming for the sake of argument, my lords, with regard to arbitrary termination of the contract. Now, my lords, while the contract, my lords, before the product, my lords, was actually delivered to us, the contract, my lords, was terminated. There is a finding, my lords, of the learned single judge, my lords, that there is arbitrary termination. Now, that is nothing but a breach of contract, let us assume. Now, the question is, their invoice is for 4 crores. They were paid, my lords, 1.5 crores as advance. Now, the learned single judge, without an adjudication, on the amounts that they have actually spent on the matter, because when they during the pendency of the writ petition, my lords, they have submitted the film. A committee was constituted, my lords, where the learned single judge had permitted us to constitute a committee, and my lords, the film was exhibited before the committee. The committee found, my lords, the film was raw, generic, unfinished, my lords, and not capable of my lords, presenting before the Invest Karnataka forum. My lords, we had a global investors meet that takes place every year. In 2012, my lords, a 3D film of 5 minutes, my lords, was the contract that was awarded to them. It was felt, my lords, that later on that the amount of 4 crores was high for the amount, but that is a different aspect of the matter. Now, my lords, the film having been supplied by them by email, our case, my lords, is that they have not completed the entire. Now, the learned single judge even relegates the remaining aspects to arbitration. What I'm saying is there has to be adjudication, my lords, under section 73 of what amounts they are liable to pay.
73 of contract.
Contract Act, my lords. Without adjudication, kindly see the finding.
Did you file your counter in the main petition?
Please, my lords, it was filed, it was contested.
Disputing the amount.
Disputing the amount, and committee was constituted. Learned single judge says, constitution of the committee.
4 crores.
4 crores, my lords.
7 lakhs.
Please, my lords. 4 crores and 7 lakhs.
You have paid out of that, you have paid how much?
Advance was paid 1.5 crores. And my lords,
description of accurate. So this is a case of quantum merit. Quantum merit points are always for adjudication. Mr. Patil,
please.
It's a matter falling into doctrine of quantum merit. Quantum merit, the apex court said,
If
fits
that-
into arbitration clause.
I understand, my lord, if that were to be in any way a condition in the order that was placed, yes, my lord, that would be the,
No, learned single judge, read about direction number 3.
please.
He has directed for arbitration. There cannot be, he cannot decide the quantum merit at all. Whether film is of this, our goods are of our description or not. How writ jurisdiction can, in that writ jurisdiction be adjudged?
In this, damages, etc., is altogether different. All that I am saying is, you have made me contract with several people for producing this film. Now you don't pay. Other people have already filed cases against me. It is not the function of the state to drive a person to financial ruin.
But it's a contract, commercial contract.
Commercial
So it's a
contract.
council prayer for recovery of money in writ jurisdiction. Number 2, contractual area. Number 3, the arbitration is already provided. Number 4, you are avoiding thereby the court fee, which could be a subject matter of civil suit. On all these counts, this is
As regards the payment of the contracted amount,
these are broad things
they
we are
cannot
indicating.
take this defense at all.
It's a matter of adjudication once they dispute the amount. Question of leading of evidence.
Directed arbitration.
Even in ABL case,
Page 40.
Correct.
There cannot be, in matters arising out of commercial contracts, there cannot be a halfway treatment in the writ jurisdiction. That's how apex court has said. Apex court followed a decision of American court, Justice Neely of American Supreme Court of a particular state, and said that way.
as regards that, my only submission to pursue your lordships is kindly peruse the decision in ABL International Limited.
Not have bifurcated. The doctrine of quantum merit cannot be decided by the writ court.
Kindly see ABL International Limited. Dispute for the sake of dispute will not oust the jurisdiction under 226. Even that can be, in a given case, even that can be done. ABL is a case of specific contract.
It fits into the LIC of India or Escorts versus LIC of India. If it is a contract not involving public law elements, even if the other party is a state, Justice Chinnaparetty's, Honorable Justice Chinnaparetty's judgment, if it is a contract abundantly involving commercial elements, even if the other side is a state and disputed questions are involved, no writ jurisdiction. 86 Supreme Court, maybe 85, 86 Supreme Court, 1986 Supreme Court.
I think, my lord, your lordship may kindly peruse ABL. We have given that judgment 2004 3 SCC 553.
(2004) 6.
2004 volume 3 SCC 553.
560. What does it say?
That will be page 37. In this, my lord, the Export Credit Guarantee Corporation was the person who had, was the entity who had guaranteed or taken out insurance. It went on claiming that there are disputed questions, it cannot be done, etc. But the Supreme Court said, not only in this case, Even in a case where such a situation arises and the dispute for dispute's sake would not be a ground at all. There was an arbitration clause. Even then the court said no. Court went to the extent of saying in a given case, evidence can also be recorded, though we don't usually venture into that.
Was it a contract under statute?
No, it was not.
Private contract?
No.
Huh?
It's this, the one involved in this case was
No,
not.
no. In that case, the case which you
No,
want to press into service.
It was not
Export
statutory.
credit,
Export Credit Guarantee Corporation is one of the corporation which takes out insurance on articles which are to be exported or imported. Kindly peruse para 23, madam.
contractual.
Para 23 may kindly.
So contractual aspect coupled with absence of
Judge agrees.
public.
Learned single judge agrees that it's a contractual matter and therefore relegates to the arbitration. How part of the dispute can be entertained by him? That is unheard in contractual matter in arbitration law.
Under the direction, what amount you are supposed to pay? 2 crores.
No, it's the entire 4 crores. Without adjudication, court says the contract amount may be paid. And during.
So this amounts to adjudicating without adjudication.
Without adjudication, there is no adjudication. And the
So
court says,
adjudication as regards the contracted amount 4.5 crores is concerned, adjudication will not come into picture at all. They have to pay that. Over and above anything else is to be claimed by me, then they can say several things about it. The direction as issued by the learned single judge is this, my lord. Kindly see page 47.
So your cross appeal is for against entire order.
Please, minutes.
And your agreed part in part.
No, they are not agreed in part. The second appeal, 12.1 millards, is filed by the instrumentality. Respondent, the state was the first respondent.
Correct.
The respondent number 2 and 3, from whom they got the contract, that they are in appeal, millards.
So you are challenging the entire part of direction.
Entire part of the order.
Both of them are challenging entire.
That the part of the.
No, they are not agreed. They have not filed any appeal. They are only in contempt. They have accepted the entire order.
He's already holding one. Already amount paid is 1 crore.
1.5 crores with subject to TDS. And
No, that is not the amount.
So that is admitted amount according.
That was that was advance amount. Advance amount, and they had given a security, millards. And millards substantial. Arbitration, millards, substantial amount is there.
The relief that is granted is this, my lord. Mandamus issues to respondent to release the balance payment due to the petitioner in terms of the invoice. That is 4.5 crores or what was the amount fixed. It is that amount which is directed to be paid.
So 2 appeals common. Yeah, which are they? 12.1.
12.1, 12.2.
12.1 and 12.2. Also 12. 12 is content. So all we it is same. 12, 12.1 and 12.2. The caption writ appeals are the gross writ appeals filed by the respective parties, whereas the test is the contempt proceeding arising out of the judgment and order impugned in the writ appeals. We have heard learned advocate Mr. H. Mohan Kumar, the appellant, in heard learned senior advocate of the party, assisted by learned advocate Mr. Mohan and learned, what is your good name?
They are the respondents, my lords, in fact. I am Ruben Jacob, Additional Advocate General.
So and so for the state.
State, my lords.
Additional government advocate.
Additional Advocate General.
Your advocate general.
Please.
Sorry. For the state, in the respective, for the respective parties in both the appeals. Learned counsels for the party stated that they argued the appeals finally. They further stated that the pleadings are over, no further are required to be added or implemented. All the three cases are reserved for judgment.
Right.
December 13, G.R. Mohan.
Appear for the complaint.
File the affidavit, my lords.
Just now, half an hour back, they served the copy. I will go through it because it's not in compliance with the direction issued by this court. Your Lordship. I'll go through it and come back. Direction is to, in the last occasion also, the court passed the order for compliance of the shifting of the shops which is in the upper basement floor of the general shopping complex.
I appeal for the accused, my lords. My lords, on the last occasion, I was asked to file a better affidavit regarding the fire safety measures which has been taken in the building, my lords. Regarding that, photographs from page 84 may be seen, my lords, wherein though the responsibility was
BBMP.
Yes, my lords, I appeal for PP.
Then the space is available, made available for parking.
They have not made them apart.
Space is available, made available for parking.
Yes, my lords, what has happened is at page
Fire
9.
safety will come at a subsequent stage. Firstly, you are supposed to, after 3 years, make available, vacate the basement and make it available for parking.
The genesis for that is, my lords, we had entered into an MOU with BDA, which is another state authority, for development of the shopping complex. There arose certain issues between the BDA and its contractor, which led them into arbitration. The matter is now pending before there, and they've discontinued to develop the property anymore. By then, they had developed only one block, which is a block 1. And in block 1 are all the shopkeepers who have now been running their trades, my lords. In the impugned order, my lords, there was a direction which was given, if I may turn to page 22 of the petition, my lords. We direct that the BBMP shall ensure that the upper basement in the first block, which is now utilized by giving temporary accommodation to old licensees, is restored as parking immediately after the completion of the second, third, and fourth block of shopping complex. Now, the second, third, and fourth block of shopping complex has not been completed by BDA because there is a pending litigation between them. In the meantime, the steps that we've taken, my lords, is that we've taken is, now we issued them notices, third and fourth floors of the same blocks have been vacated. And we are asking all the shopkeepers who are in the parking or the basement to move their trade to the third and fourth floor, my lords. All the amenities regarding lift, toilets, all hygiene waters has been provided to them. Despite the notice which is issued, which is at page 94 of my affidavit, my lords, they're still restraining from going up, going.
So unless they vacate, you will not be in a position to
No,
do
we have already installed the fire safety measures.
fire safety measures.
Yes,
you
my
have
lords, that has been installed. That's at page 84 onwards. The photographs are shown.
What other things to be done in the?
My lords, this is only the minimum safety measures which has been implemented, because the safety measures had to be implemented by the BDA, who are the developers. Now they are unable to do it because they're saying that the person who did it in the first place and who did a half job has now been transferred. We'll need to locate it. In the meantime, BDA on its own, to ensure that there is no harm and risk to the shopkeepers there, have allocated around 5 lakhs, 4.98 lakhs, and installed all the minimum safety measures which has to be taken regarding fire measures throughout the building. In the meantime, since further measures will have to be taken, we are asking them to shift to the second, third, and fourth floor, where we'll be able to complete all the fire safety measures.
You will be shifting all those occupants in the above
For the
floors.
temporary measure.
That's
my lords.
what.
Yes, my yes,
Till
my-
this is accomplished.
yes, my lords. That is at page 94, the notice. They're yet not moving upstairs.
Notices have been issued.
Yes, my lords. It's stuck on all the shopkeepers' shops as well, which is also produces photographs here then. The direction has been to be given, my lords, they can be shifted.
That will take how much time?
My lords, they need to shift. We are asking to shift, we are making oral requests. They are not moving. If a direction is issued by the court, that will empower us to,
But they are not parties here.
they're not parties here.
Because the affidavit is filed by the BPP, that they will do it.
I agree.
That is the problem.
But then-
Otherwise, 'cause they are not filed any affidavit or any objection.
It's all right. Now they have page 93 of the objection.
BDA made a party.
They have said, we have already issued notices to the occupants to go to the above floors. So that if you yield a place, we will accomplish rest of the things.
So kindly see for a moment, page 23 of the order, specific order. Your Lordship. Section B. Clause 4, page 23 is very clear, because this court is also not approving about the, kindly see page 23, clause 4, Your Lordship. We make it clear that the grant of time of 3 years shall not be construed to mean that this court has approved the action of BPP using the basement of first block for accommodating shops of the old licenses.
That's
The
right,
court
but
has also not approved it.
If people do not go to the next of the floors, how the work to be done?
Because they have to do it, that's what the bell.
How?
First of all, the very providing of that shops to them in the accommodated basement is illegal, basically.
The person know. This place.
Your shifting, Mr. Council, is dependent upon the arbitration process.
My lords,
Shifting of the shopkeepers
yes, my lords.
to fourth floor
Yes, my lords.
will depend upon the outcome of the arbitration.
No,
process.
not at all, not at all.
Then when will we going to do it?
My lords, we have given them notices. We are requesting on a daily basis to move, but they're not moving at all.
Rules made in PI jurisdiction. If that is so, they need not party. We can tell them to use the force and we can say. The place and shift, be shifted. We can. In this one. It's not PI jurisdiction. It is PI jurisdiction.
The affidavit is filed by the BPP on 23/9/2019. Based on that, this court at para 4.
We have issued notice to the occupant. We are not obeying the notice.
Mere issuance of notice is not the where you can rest.
Something you have to take,
Something you have-
issuing notice, nobody will do things by notice, even by orders of the court, things do not move unless some heat is generated. What you have done?
My lords, we've made the third and fourth floor completely comfortable.
You
for
have
them
kept
to-
everything ready,
Yes, my lords.
but the bride and bridegroom have to occupy the space. For that, what you have done? That does not happen by goodwill.
No, not at all.
You have sent notice.
Yes, my lords.
Then what happened?
We have been going on a regular basis asking to move because we have to.
And
install
every
the
time,
fence.
whenever you go, they say, no, we will consider. Then what? How long the order should remain uncomplied?
If a direction is issued by this court, that same should be taken, I mean, if they can move upstairs, until then we'll be able to move them, my lords.
No, brother, there is a page 23, which Mr. Mohan is pointing
lords.
out.
Yes, my lords.
Face direction number 4 now.
Yes, my lords. We make it clear that the grant of 3 years shall not be construed to mean that this court has approved the action of BBMP using the upper basement or the first block for accommodating the shops of the old licensees.
Yes.
I understand, my lords, but if that has to be read along with the direction number 2, we direct that the BBMP shall ensure that the upper basement in the first block, which is now utilized by giving the temporary accommodation to the old licensees, is restored as a parking immediately after completion of second, third, and fourth block. So both have to be read in conjunction.
That's true.
This can be complied only after second, third, and fourth block is
We
completed.
are asking you,
Yes, my lords.
where the licensee does not obey your notice,
Yes, my lords.
what is the legal recourse available to you?
We either
You have,
we have to either
you
cancel
have
the licenses.
already blocked certain premises on the ground that they have not obeyed your directions. And matter is, one
But
of the
that
matters
now-
came before us other
Yes,
day.
yes, my lord. That
Why are
ceiling-
you not taking such an action here?
That ceiling has been now considered as illegal because until the writ appeal is considered.
Not ceiling, there are many recourses available.
I'll look into that, my lords.
Now go to the first direction.
My lords.
First
First
direction, very
direction,
first
page
direction.
22.
We directed the BBMP to implement the assurances given in para 3 and 4
See
of the
the-
affidavit,
What was the assurance?
that in 3 years, this buildings will be
So is
complete.
there any impediment now?
Yes, my lords.
What?
My lords, the MOU had been entered with BBMP.
That we are not concerned.
My lords,
When is your affairs?
BDA was to construct this property. They ran into some litigation with their own
You are
contractors.
saying that fourth floor is available.
Of one building, my lords, of the first block, if my lordship will look into this,
How many buildings?
what we are talking about is the directions regarding second, third, and fourth block. Where the shopkeepers right now are in the first block. In the first block, they're occupying the upper basement. We are asking them to shift to the third and fourth floor so that we can implement the fire safety measures in its complete measure. They're not cooperating with that.
Try to take, remove those persons.
The lordship look. Photographs,
We want the thing.
annexure D1, annexure D1.
Whatever you do.
They are
but
not
you
demolished those shops also.
Kindly listen. Whatever you do,
Yes, my lords.
whatever method you adopt,
Yes, my lords.
but we want compliance.
Yes, my lords.
You can't sit tight by saying that we have issued notice and they are not implementing the over notice. That is no answer in contempt.
I may be allowed to file a better affidavit in 2 weeks, my lords.
No better affidavit,
Action.
better compliance.
Yes, my lords. Better compliance. I'll file my complaints in 2 weeks.
So will this will list on, because you appear to be giving excuses that we have issued notices, although everything is ready. Floor is ready, fire safety measures are ready.
Yes,
The
my
only
lords.
defense forthcoming from your side is that we have issued notices, nobody is vacating or nobody is shifting. That hardly convinces the court.
I'll file my complaints.
And then don't tell them to approach writ court again. Those
No,
people.
my lords.
In fact, your lordship, page number 29, your lordship.
Now we have
Annex photograph. No, they're saying that 2, 3, block number 2, 3, and 4 has to be demolished and we have to consider. Still shops are there. This photograph which I produced along with the contempt, the old shop still it is there.
Once the
Somebody is
contempt,
occupying in that
once
also.
the court is seized of the contempt,
Yes.
the complainant has no role. Yeah, we are dealing with
Please.
this. Yes. So
2 weeks.
the
my
next day,
lords. 2 weeks, my lords.
some concrete compliance.
I will do that.
2 weeks only. So 2 weeks will be 16th April.
Hello?
16th April.
Yes,
We are granting more than 2 weeks,
yes, my lords.
but do it.
Thank you.
Yes.
Date maybe.
16th April.
Public.
Number 14. Raghunath MD.
Here in 14.1, these matters what pertain to, my lord, a direction which is not complied, whereby the tenant has to deposit rents pursuant to the orders of the learned single judge. Those directions, my lords, will get at Annexure G, page number 120.
May I make one submission, Lord? All these three matters are relating to the same order. In respect of the third matter, it appears that there are certain office objections. We'll comply those office objections and the matter may kindly be listed in next week.
So which direction you want to comply?
My lord, learned friend has to comply the directions.
Which direction? Tell
Lord,
us.
Lord, I am for the complainant.
Read the direction.
Read the direction.
Please, my lord, kindly take annexure A in 14, please.
Page 104.
Please, 104.
Lord, if my lords have, my lord, 14.1 or 14, my lord.
CCC
1050.
That is the first
1050.
matter.
1050, my lord may kindly come to annexure A, page 26. This is the earlier order which is passed to the learned single judge, directing us to pay the rent to the landlord, please, my lord. But subsequent to this order passed on 22nd March 2017, I as a subtenant, lawful subtenant, file an application before the court below under IA3, which is at annexure B, seeking directions to the first defendant to deposit all the rents which I have deposited with it.
Where is the direction?
Please, my lord, that direction, the trial court passes an order at annexure D, and that was confirmed by by the Honorable High Court at annexure E, please, my lord, at page 88.
88.
88, my lord, 9th August
Same,
2020.
page 104.
Please. Page 104, the operative portion says, the petition starts disposed of, permitting the petitioner to deposit rents received from
So
the.
where is the direction?
Lord, I as a subtenant have
Where
performed
is
my
the
act.
direction? Which direction we can enforce?
My part of the work, I had to
Which
deposit.
direction the
Please,
court
my
can
lord,
enforce?
the
Where is
rents
the
which they
mandate,
have
brother?
received.
Where is the mandate? That's right.
Where is the mandate? Sanction is given, license is given, permission is given. Where is the mandate?
I understand, please, my lord, but there is a direction in annexure A that I'll have to pay rents.
Lord,
Annexure A.
Yes, please.
there's an earlier
Page
order.
number?
where
Earlier
there-
order.
Earlier order where there is a direction. And that is confirmed, my lord, in the subsequent order. My lord
Written.
takes, my lord.
Is the order brought under contempt? This page 104.
104 in the first.
Then we don't see any mandate which can be
My
complied
lord,
with. in the
this
contempt.
order has to be read in conjunction with the annexure A, please, my lord. Because while looking annexure A only, the learned single judge has passed an order saying
We
that.
appreciate, but we have to go by the language of the order of learners.
Lord,
If
my,
there is
my,
no,
en- my,
if there is no contempt, there is no contempt.
may I make one
The suit is
submission?
pending. Suit is
Suit
expedited.
is decreed.
Already expedited.
Suit is
Suit is
decreed.
Suit is
disposed.
decreed, suit is disposed of.
Execute the.
Lord, they have to deposit the rents. In 14.1, my lord, if I can point out. Lord, page 48.
In your
Yes, my lord, 14.1.
14 point.
1, my lord, that is CCC, my lord, 626 of 2022.
There are direction.
Yes, my lord, there's a direction.
1184.
Lord, CCC 626 of 2022.
14.1.
14.1. My lord, I am the landlord. Lord, page 48, if my lord sees, page 48. Please see para 29, my lord. Page 48, para 29. Lord, last three lines, IA number 2 is allowed in part, directing the defendant tenants to deposit the rents from the date of filing of the application till the date of disposal of the suit, which will always be subject to the outcome of the suit. My lord, therefore, there was a direction to deposit.
Now, what the contemner does, my lord, is despite this order being passed directing deposit of rents, he collects the rents, my lord, and retains it to himself. Then, my lord, application is filed. Lord, virtually this order is being frustrated. This order, my lord, is being frustrated. Now, what the tenant does, my lord, is he collects the rents from the subtenants, retains it to himself, and then we initiate contempt proceedings, my lord, earlier round of contempt proceedings, saying that this order is violated. Then, my lord, my friend who appears in the other matters, he files an application saying that I have paid the rents to the tenant, and therefore he must be directed to deposit the rents. That is favored by the trial court. That order, my lords, will get at, my lord, page number 81.
Now suit is decreed.
Now suit is decreed.
For?
My lord, suit is decreed for eviction and, my lord, payment of arrears of rent.
Execute.
Yes, my lord, I will execute it, but the direction given by the court, my lord, to deposit remains uncomplied. What happens, my lord, is the direction is to the tenants to deposit the rents. Now, my lord, the accused 1 to 4, despite there being this direction, collects and retains the rent. And it is not deposited in the court. Ultimately, it was made subject to the outcome of the court.
That's true, but now decree has been, you have obtained a decree.
Yes, my lord, decree is there.
Execute the decree. Your rights actually materialize.
Yes, my lord.
In terms of the decree, notwithstanding order of this court.
Yes.
Because court directed disposal, early disposal of the suit.
True, my lord, but the direction is also to deposit.
These are all interim orders. You were in GMCPC on interim orders.
Yes, my lord, these are all interim orders.
So all interim orders merge into the decree.
Yes, true, my lord, but only question is
It
whether
does not
the-
have identity now because of.
Yes, my lord,
merger.
it merges with the final order. The only question is, my lord, can the tenant be permitted to, my lord, disobey a direction, illegally collect the rents and retain it to himself? In all fairness, it should have been deposited with the court so that, my lord, my filing one more round of litigation execution petition would be saved. The direction was to deposit it in court. Had it been deposited, my lord, I could have withdrawn instead of one more round of litigation, my lord. So therefore, in essence, my lord, it is frustrated is my respectful submission.
What is the total amount?
The total amount that is due under the applications, my lord, is about
1,22,750 in the
about
first
14
matter.
lakhs, my lord, is due under both the applications.
And pursuant to this order at page 14, 48, 49.
Yes, please, my lord.
What is the amount required to be deposited?
My lord, 14 lakhs is required to be deposited. He has not deposited one naya paisa, my lord.
Now decree is also for 14 lakhs.
Decree is for, my lord, depositing these rents and memo to be filed by the parties, my lord, to determine what is the amount payable by each of the parties.
That means what you like. That's not permissible.
There is a direction for return of the amount in favor of the plaintiff.
What you want to say is, I want to execute the decree by enforcing order of the learned single judge. After there is direction by the learned single judge, is true.
Yes, my lord.
But there is a doctrine of merger also now. All orders would otherwise, by enforcing the contempt action, we will render execution of the decree itself.
No,
You
my
need
lord.
not go for execution at all.
The direction is to, my lord, deposit the rents in the court, not to give it to me, my lord. That is the direction. If that was earlier direction was to pay the money to me, my lord, then I bow down to what my lords are saying. But the direction was for the amounts to be deposited. Rents, my lord, he is staying there. In all, my lord, fairness, he must, my lord, deposit the rents. So the deposit was to the court. And the
Contempt against the direction, the actual direction.
Actual direction, my lord.
626. 626, yes, second.
What 626?
43,
My
934.
learned friends, man.
In my lord, 14.1.
626, my lord, the complainant is not the aggrieved party, my lord.
Correct.
In 626, my lord,
You can't plead, I don't know, I think 100,
my lord,
115, yeah, 14, 15 of the Evidence Act. You cannot say that he is not my landlord. And otherwise also, that contention is restituted now.
no, my lord, I am not on that point.
You
my lord.
deposit the money in terms of the order of the learned single judge. That deposit you have to make. Then whatever will happen in
No.
terms of the decree will happen.
Now, your lordship may kindly,
Other court orders will not have any meaning at all.
now your lordship may kindly turn to the judgment of the trial court. I am permitted to take your lordship through the operative portion of the judgment. At page 134 in my objections, I have produced it in CCC 1184, my lord.
How that will dilute the mandate? It's only that learned
Because,
single
my
judge
lord,
said, deposit that money
Because,
in the
my lord,
court. That's all. It did not say, put that money into the pocket of the plaintiff.
interlocutory order passed by the trial court merges with the final judgment, my lord.
Not that way. Not that way. For purpose of
One
contempt.
aspect. Then
That's the
secondly, my
general
lord,
principle.
secondly, my lord, the lordship may
Interlocutory
kindly
pass-
consider.
order passed by this court merges with the decree of the trial court.
My lord,
Unknown
no,
concept.
it is not so, my lord.
Or
Your lordship may
unheard
kind- your lordship may kindly
Mr.
consider.
Counsel,
in-
order of this court merges with the decree of the trial court.
No, it is not so, my lord.
Then?
My lord, this court had exercised the jurisdiction under the supervisory power. The original order is passed by the trial court, my lord. An interlocutory order is passed by the trial court.
Principally, any order of this court will survive irrespective of disposal of any proceedings.
My lord, this court has not passed any original order.
The
my lord.
independent jurisdiction
My lord,
of contempt.
I have
jurisdiction.
filed the writ petition before this honorable court, assailing the order of the trial court, my lord. Then under supervisory power, my lord, supervisory jurisdiction, my lord, this court had confirmed the order of the trial court. It is not that an independent order is passed by this honorable court. The lordship may kindly appreciate. It is not that an independent order is passed by this honorable court. It is only under the supervisory jurisdiction.
Any other
My writ peti-
properties, your bank accounts and properties, what are the?
My lord,
Otherwise they will want to
You can't escape.
They can't escape.
My lord, your lordship may kindly consider. My lord, the trial court had passed the order. I have challenged in the writ petition. I am before this court as the petitioner, my lord. My writ petition is dismissed. While dismissing, my lord, this court had extended the period for deposit. That's all, my lord. It is not the original order passed by this honorable court. Then, my lord, the matter was taken up before the Honorable Supreme Court also. Then the Supreme Court has given me the liberty to take up the matter before the trial court. Accordingly, an application is filed. Because
order
it is a,
Supreme Court passed which order?
my lord, the Supreme Court had passed an order. The Supreme Court had
Confirm.
given me the liberty. Supreme Court had given me the liberty to approach the trial court by filing necessary application. Then an application is filed. Then the trial court had disposed of the suit. That application is considered along with the main suit, my lord. While disposing the suit, the trial court said, let both file a memo of calculation and let the trial court will decide who is entitled for what amount.
No, not entitlement. We are not on entitlement. Please understand. Decree speaks of entitlement. The order of the learned single judge, which has been affirmed by the apex court, does not speak of entitlement. It imposes an obligation per se on you to deposit particular money in the coffers of
With
the
the due
court.
respect,
That's all.
With the due respect, my submission is, it is not the original order passed by this honorable court. It is only passed under supervisory jurisdiction, my lord. Article 227. It is not the original order, my lord. If your lordship could kindly turn to page 134, my lord. the operative portion of the.
We have no other work than reading the papers.
I'm
Before
sorry,
we
my
put
lord.
so many questions so
I'm sorry, my
confidently.
lord. I'm sorry, my lord. It's not that. So far as the rent payable to the landlord is concerned, my lord, that has already been paid and there is no arrears. If they say that this is the amount to due, we are ready to pay that in the court itself, my lord. For any reason, if they say that this is the amount due. Therefore, and with due respect, my submission is, so far as the first complaint is concerned, it is not available to the complainant because she is not the aggrieved party. So far as the second complaint is concerned, my lord, may I make one more submission, please, my lord? So far as the second complaint is concerned, my lord, there is impersonation before this honorable court, my lord. The complainant is not the original party. It is a proprietorship concern. One Mustafa was the tenant under these accused persons. And now one Mohammed Shani has filed this complaint, my lord. And even otherwise, my lord, that is barred by limitation, my lord, section 20 of the Limitation Act, section 20 of the Contempt of Courts Act.
For the counsels for the respective parties.
Then, despite this, my lord, if this honorable court comes to the conclusion that I must deposit, then at least some reasonable time may be granted.
While undertaking, so that we need not take undertakings, a pass order at all.
Pass orders.
But orders of the court will not leave uncomplied, come what may, because these orders of the court. What is fun in making the orders and not implementing them?
1 week time may kindly be granted, my lord. I will file necessary.
So you are undertaking to deposit the rent.
My lord, I'll file memo so far as that a breathing time may be given, my lord, in such cases. Sufficient time may be granted.
Fair enough.
Yes, my lord, yes, my lord.
And with the liberty to me to pursue the matter before the trial.
So on which date? For that purpose only.
Next Monday.
Very well.
Next Monday, my lord.
Next Monday. Next Monday.
I'll take instructions and file necessary memo to that.
25th.
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 Grateful, grateful.
So you will be depositing the rent as per the directions in this 1184.
As per the direction of the
any
trial court,
adjustment-
my lord, it is not the direction.
Any
direction of-
adjustment to be worked out.
Before the trial court.
Correct.
Yes, my lord, yes.
Because
I'm
the
grateful.
original order is passed by the trial court, my lord, not by this one.
Even if you are entitled to some refund before the trial court.
Yes, sir, very well, very well.
I am entitled for refund of that amount only, my lord.
So you
But
work
that
out
effect,
the-
while
in the-
passing the judgment, my lord, the trial court has.
Before the executing court, you work out.
Yes, very well.
You deposit as per the directions. That is all we want. Nothing more.
And you have sought for time and we are giving time now.
Please, please.
Obliged.
Grateful.
Obliged.
December 15.
My lords,
On DK.
for the accused, my lords, I seek a short accommodation of 2 weeks, my lords. I'll file my affidavit.
Only representation is to be decided.
Please, my lords. Yes, ma'am.
2 weeks.
Yes, ma'am.
Learned counsel, Mr. Prashant.
Yes, ma'am.
SS for the respondent, 6 time.
Request for
Stating that within 2 weeks, the directions will be complied with.
Yes, ma'am.
Stand or 2 days. Are you satisfied with this?
They are giving an assurance to us that they are passing the order
Please, ma'am.
in compliance with the order.
Learned counsel,
We will
Mr.
dispose of it, we try to revive it with aggravated.
Prashant SH stated that the directions of learned single judge brought under this contempt proceedings shall be complied with within 3 weeks from today.
Grateful, my lords.
Full stop. In view of the statement, the applicant represented by Mr. Nishant GK stands satisfied by this statement. Full stop. Since the Directions will be complied with within 3 weeks as stated by learned counsel for the respondent. The contempt proceedings are closed with an observation that non-compliance shall have exposed the respondent to the aggravated form of contempt.
Yes.
16 urgent, seal number 17, Mr. B. Ramesh.
Lordship said, asked us, directed us to file the synopsis, Lord's. Replace the synopsis, is that interpretation of second proviso to section 49 relating to the motion of no confidence. Lordship said, directed us to file the synopsis. We have placed.
Lordships heard the matter and said no more submissions on 18th. So our written submissions are before Lordships. Ada? Correct?
The point number 6, my lords, I'm a little doubtful I'll have to come because there is an issue relating to whether right to vote is a constitutional right. Reference to the.
That is referred to the larger bench now.
Now, no, that has been decided in that election, appointment of election commissioners.
Now it is referred
To a larger
bench.
That's the only thing, because there is a reference, that's all.
That makes no difference to
That
them because
we hear
by,
it, that's
by
only.
reference, the presidential value of a judgment is not
never
lost.
lost.
It is not lost. But here, my lord, that was considered. Anyway, that may not directly raise.
And we rest our submissions, my lords.
What is the remainder term?
Lords,
What is the remaining period is?
my lords, July 2024. 17th of July 24. My term would end as a adhyaksha.
The first
The-
term of the 30 months will end.
No, newly elected.
His
Yes,
term will end
it
on
will end on
17th.
17th July.
This July.
This
17th
July
July.
24. I've given it in my list of dates, my lords, along with my synopsis.
Every time this arises.
Lordships. That
Council's name assisted by so and so. Permanent councils for the respective parties stated that they argued the writ appeal finally. They further stated that the pleading no further are required to be added or supplemented. Reserved for judgment.
These two persons.
the
What time?
Within what period he will be able to accomplish the elections?
My lords, in terms of your lordship judgment itself, what your lordship has said, comply with 13D, go ahead with the election.
No, that was a case, as he rightly pointed out. That was because I know that. That was a case where the charge was not taken. The charge was not
No,
taken.
in that case also administrators were appointed.
No, I think
That
the
was
one
not taken.
last sentence we have added
I'll just
to
read.
ensure that it will not be quoted as a precedent. I vaguely remember.
No, man, I'll just read out.
Right.
The judicial administration shall take over the function of the board of the appellant, the cooperative society, if not already taken. In fact, your lordship directed to take over charge and
Correct.
asked it whether whatever interim order stands so and so, my lord, all adverse remarks stands set aside. So there's no specific.
No, I think
4 months time from the date on which they take over the charge.
Some word I remember
What
where we have said that in the peculiar, something like that. No word.
No, court officer. I'm sorry, I just got one copy.
That-
my lord.
But elections are required
No,
to be
we'll
conducted
hold
within a
the
period
election.
of
We are not
8
shying away
weeks.
from holding the elections, my lords.
Time factor.
Time factor immediately, my lords.
May I just pass on one more copy, my lords, for your lordships. Yeah. Lordships had directed the elections to be held within 8 weeks, and that was a case where your lordships had passed an interim order that the administrator will not take charge. Then by virtue of the orders, your lordships permitted the administrator to take charge and hold the elections within 8 weeks.
We are not shying away from holding election. The question is when it should be held, my lords. The only.
There is no question of any discretion.
That question is answered by the statute book.
No statute, therefore, my lord, now the question is, my lord, the officers concerned are not available to hold the elections, my lord. That's the only thing, my lord. If the officers are available, we will hold the election. It is nothing, not that we don't want to hold the elections. After complying with rule 13D, we will hold the elections.
Law provides 6 months.
6 months, any reasonable time, my lord.
Law provides
6, we'll hold the elections within 6.
29B3.
Lords, 28B3.
B3 prescribes what is the period?
Lords, 6 months from the date on which the administrator assumes charge. Administrators assume charge on 30/10/2023.
13/10.
Yes.
So 6 months will be expiring in
April. So they have to conduct. There is no way that they can escape. Lords, if your lordships were to recollect, the constitution bench in a case where the holding of the elections for the president on account of we are only saying that election should be held in terms of 28B3. 28B3. Lordship's judgment. My lords, page 49 of your lordship's judgment, my lords.
Apparent difficulty since this concession is being made in the
So
peculiar.
ideally, study should come out with the notification. Ideally, in law, you are expected to come up with notification within this, within the
stipulated period.
stipulated.
Well, insofar that now what has happened,
But then you will be committing breach of this. That's what. Apart from anything else.
Manoj, I appreciate what rule 3 says 6 months plus 3 months. Manoj is what is contemplated under 3 months. Because it says provided that administration so appointed shall not continue for the period beyond 3 months in respect. So it is 6 plus 3 months is what is contemplated under the statute. Now, Manoj, in view of the peculiar facts where the parliament election, Manoj, the question is whether simultaneously, Manoj, both the elections can be held. And it is statewide, Manoj, the number of societies are huge, Manoj. It would virtually, it has a cascading effect of holding parallel. So therefore, Manoj, your Lordship may kindly seek instruction, Manoj. Immediately after the period of election, at the earliest, we are not even seeking a day's delay, Manoj, we'll hold the elections. Manoj, this office, none of these officers are given at the election commission's hand, Manoj. This does not happen day in and day out. These are genuine
reasons, my lords. In fact, under section 121, my lords, directions can be issued. In exigencies, my lords, it can be issued by the state government to hold elections, give suspension to, your lordship may kindly say section 121 for a moment, my lords.
No, if if legislature wanted that the election process be it to the center or to the provincial legislature, were to be a ground for extension after independence.
There are
Several
there are
elections have been.
one or two judgments which I like to place also, my lord. They say that under 121, it can be suspended under peculiar facts and circumstances, my lord. I've not bought it right now, my lord. Under 121, in fact, I'll just. This is the March 11th portion. The state government may by general or special order publish in the official gazette exempt any corporate society or a class of corporate where provisions of this act may direct such and such apply to such society, class of such for such modification. Therefore, this class of where it has expired, my lords, only for a period of 3 months or 2 months we can exercise power. Their judgment, I'll seek instruction. Kindly have it next week, my lords. I'll place
Under
for your lordship.
121.
They are losing out time on that, taking instructions.
Under 121.
121.
This, according to you, gives power to the state to
State.
elongate the period, the timelines prescribed by the legislature.
Certain provisions like 123 subclause 3, my lords, suspending it for a limited period because of the ensuring elections or special circumstances, my lords.
This is against the basic structure doctrine of the statute. The basic structure doctrine of the statute, because it's more in the light of your powers to cause any amends or suspend the provisions. It doesn't happen that way. The moment that
As
times
your
are
lordship
fixed.
pointed out, these have come out earlier also, it's from independent.
But,
There are,
the doctrine is confined to only constitutional
No, I'm,
jurisprudence, says Indira Gandhi.
Lord, that I'm aware, Vinod. On the later side, it said the basic concept with which the statute itself is evolved. If you make a suspension of the kind, statute itself withers away. There is nothing in the statute to be taken forward.
Now, this relates to the all cooperative societies. in this
Lord,
state.
it's only pertaining to 2 cooperative societies which are now before your lordships, where administrators have already taken charge.
Speaks laws of cooperative society.
we'll get back and seek instructions on that and.
Lords, one thing. One thing which I.
Under our election commission, we have representation, 1950 Act 51. Election commission as such, it does not have its own employees at all. It depends upon employees is drawn from this one. Therefore, as to say, you can say, so for the only 2, yes, for these 2, we have compelling requirement. Therefore, don't draw any officers from our office. It's not that all officers are that will find out.
10 days, my lords. In
Lords,
fact,
the whole
can we
object.
have it
Lords,
after 10 days, my
When
lord.
it comes to end,
Lords, April, 28th of April, it comes to an end.
therefore 10 days we is asking.
So you have to save yourself and you have to save
But,
us from
April-
passing the order.
Lords, I just want to say this, Lords, if the officers are not available, the very same officer who is appointed as an administrator to my society is the officer who, according to the state government, is required to discharge the official functions. Then I don't have a body. I don't have a person who can administer, and I cannot run the society with the staff.
My lord, that's a difference from conducting day to day and from holding election. My lord. Holding election is entirely different from conducting day to day affairs. You can't compare these 2 aspects.
No.
my lord.
Let Advocate General.
Of course, my lords, I'm in your lordship's sense.
And insofar as that is my, those 2 notifications, my lordship may, I'll place it on record for having withdrawn.
But there. So we'll just record that the prayer B cannot be granted. Very good.
Lords, no, on this notification, I'm not sought for any relief at all. This was a subsequent event after the writ appeal was
But
filed.
you have,
Lords,
you have produced those.
I had produced the notification, you lordships
Take a
may
note
pass an
on
order.
that, on the
Lordships.
submission of learned advocate.
So the present writ petition contains the twofold prayers as in the Roman 1, Roman 2, bracketed portion, page 29. In course of the consideration of the petition on the last occasion, learned advocate Mr. Ravi Shankar
Lordships.
for the petitioner produced, not produced, showed to the court. Two notifications issued by
the state government.
One notification produced by, notification dated so and so and so, issued by 13/3/24, issued by so and so such and such authority, whereby the term of the office of the members of the cooperative society concerned were extended
Till holding of the elections.
in view of the impending elections.
No, that was
because
not the
impending general elections.
Impending general elections to the parliament. However, the said notification came to be rescinded by subsequent notification 16/3/24. The rescinding notifications were produced on record by Learned Advocate General, Mr. Shashikar, which is taken on record. Even otherwise,
there are two kinds of.
even otherwise, in law, the prayer small Roman 2 could not have been granted.
Lordships. No, that is not essentially the, what I have sought for in the writ appeal itself, but
First,
innocuous
the
observation which
that
your
we will
lordships
not-
is
will
making.
not record that. We will
Lordships.
record on.
Only there are two problems for this now because of the thing. One where calendar events have already been issued, Manoj, which is ongoing. What should happen to those? Second thing where administrators have been appointed and the period of administrator is expiring. These are the two issues in quite number of cooperative societies which are we are yet to take a decision on those, having withdrawn these two.
But the learned single judge, as a matter of fact, quashed these notifications, earlier notifications in respect of those societies where calendar of events have been issued.
No,
Saying
they
that
do not quash.
to the extent of those petitioners, that's
Court has
because-
permitted to where calendar events have issued, where counting was pending, court said go ahead and finish the counting.
no, even the elections, wherever the elections were directed, because I appeared in the matter, the elections were scheduled to be held today. This learned single judge directed that the election should go on notwithstanding the notification.
We'll consider, we'll apply my.
Lordships,
First,
of course, the Advocate General has to.
General apply the.
Lordships have fixed a date after 10 days.
Now this administrator is appointed for some specific term?
Lords, administrator can hold it only for 6 months.
6 months.
6 months.
And the purpose of appointment of administrator is
Hold
only
the
to
election.
conduct elections, nothing else.
That's correct.
That will coincide with that.
So, in the usual process, Manoj, it would have happened, Manoj. Now the only question is what to do in view of the.
That's what the administrator, the language employed under 28B3 is, as soon as possible, he has to hold the elections, not later than 6 months.
9 months, 6 plus 3.
No, there's only 6 months under 28B3. There is no further 3 months.
6 months.
3 months is given only so far as the credit structure cooperative societies is
societies.
concerned.
Find out some precedents if there are in
Please, under
anywhere,
121.
anywhere.
What, Manoj, 121,
Because is whether under 121, Manoj, whether we can suspend a class of cooperative societies because of impending election, but there are judgments both ways, Manoj. I'll be able to place before your lordship.
but the view of English authors like Erskine May, parliamentary practice, there is some reference in that where legislature fixes a particular period for doing election, not particular thing, election. Then courts cannot elongate that period nor cut short the said period.
Not your lordships may recollect, not when holding the presidential elections of presidential election country, Gujarat Assembly had not been constituted. The president made a reference to the Supreme Court. Supreme Court said the doctrine of impossibility cannot be pleaded when it comes to the question of election. Doctrine of impossibility has no applicability to the doctrine of election, to the principles of election. That's the view taken by the Constitution bench. So I don't think there is any restriction in
whether
that.
161 can be used for the purpose of elongated more than 6 months. More than 6 months is only short. Otherwise, my lords, as your lordship pointed out, it is 6 months. We have to hold elections.
Occupied field, my lords. 28B3 is an occupied field.
Other states in such a provision is there? Almost I assume that way. For 2-3 states I have seen, including my lord's state cooperative society also. But whether such provisions, how various high courts have interpreted,
Just examine
that research you have to.
That we will do it and come back.
I'm coming back only on that aspect. My lords. If something is there, I'll point it out. If not there, I'll just put it across.
Lordships. Date, my lords, after 10 days.
10 days?
2 weeks.
2 weeks.
Anyway, there's time to 26th April is the.
Lords, 26th April is the date, but they have to notify the elections 15 days. If your lordships were inclined to accept my submissions, then there should be 15 days. Lordships may fix it the latest by first week of April, not so that if your lordships were to pass an order that could be capable of implementing the mandate under law.
See, we can ask them to abide by the time limit.
Yes.
Provided in law.
That's true.
For holding the election. At the same time, court will not fix the timetable.
No, my lords.
That is also.
My lords,
Two things.
15 days. My lords, if your
One
lords,
second.
yes.
That the legislative prescription of limitation period is one thing. If that prescription is not adhered to, what would be the fallout is another.
Yes.
The second part belongs to our domain.
That is true, my lords.
Therefore, there is scope for. Yes. That is it. 2 weeks.
First week of April, my lords, if it is. 4th April. Grateful, my lords. 56 also, my lords, the same matter.
5th of Friday.
55 and 56, both matters. Grateful.
Seal number 18. Ram Murthy HS.
Petition, my lord.
In this matter, I am awaiting instructions, my lord. The direction is to conduct body and durasti.
Direction is.
They will awaiting instruction or making statement.
Because they
Then we
have
can
not
discuss.
If you say that within, because it's a positive direction, not consider, etc.
I
You have
understand.
to do body.
Yes.
How the text of the order is.
Yes.
Take time and report compliance, so that in the event you do not comply, then you will be entitled to revive it for aggravated contempt. The direction it is.
My instructions are that, my lord, this very land has been acquired by KIDP.
Possession also is taken.
Yes. That is why we are seeking time.
Then put it on the record. 2 weeks. 15th, 8th April.
Oblate.
Number 19. H. Chandrachud.
Lord, the issue is of implementation of the office memorandum at page 51, annexure A1. Lord, the government of India had issued this office memorandum to implement the recommendations of the 6th Pay Commission. Page 51. The object was to bring some parity between IAS officers and officers belonging to the organized group A sector. Lord, if I may read 2 paragraphs of the office memorandum dated 24th April 2009. Lord, page 51. Lord, it is subject non-functional accreditation for officers of organized Group A services in pay band 3 and 4. Consequent upon the acceptance of the recommendation of the 6th Pay Commission, the following orders are issued. Whenever an Indian Administrative Service officer of the state of joint cadre is posted at the center to a particular grade carrying a specific grade pay in pay band 3 or pay band 4, the officers belonging to batches of organized Group A services that are seniors by 2 years or more and have not so far been promoted to that particular grade would be granted the same grade on non-functional basis from the date of posting of the Indian Administrative Service officers in that particular grade at the center. So basically what it means, Lord, this is a financial accreditation which is granted without there being any change in the post or the duties or any other responsibilities. Lord, there are some conditions attached to this, my Lord, which would be relevant for your Lordship's consideration. Page 54, my Lord, is the annexure 1 attached to this order. At page 54, my Lord, the terms and conditions are stipulated. Item number 3 and 4 would be relevant. Item 3 says all the prescribed eligibility criteria and promotional norms, including benchmark for accreditation to a particular grade pay, would have to be met at the time of screening for grant of higher pay scale under these orders. A screening committee would be formed by the ministry for implementation of these orders. There would be 3 members in a committee so formed, and they would at least be 1 level above the grade for which the accreditation is being considered. Secretary of Ministry concerned would chair. So what it says is that the financial accreditation would be granted subject to meeting the eligibility criteria and promotional norms, and that would be considered at the time of screening, and a screening committee would be formed. Thereafter, my Lord, the Government of India issued another memorandum, office memorandum at page number, annexure A2.
Lordship, can I make a submission because I haven't served the copy of the appeal, writ appeal. He has not served the copy of the writ appeal. He has sent some irrelevant. My writ petition copy has been served to me.
Apologize that my office.
Give the
while
copy.
serving-
Maybe it may be a clerical mistake. I agree.
You said that.
I'm sorry, I apologize for that. While sending the copies, he has received, he has sent to a mail yesterday, and I was not able to comply the mail. That certain papers are missing in the copies being served to him as a caveat.
The full set has to be given.
Better do that. I will just do
Because
that.
you will not be able to,
Full
all
copy.
we will not be on the same page.
But I'm sorry, Lord.
What is your case?
Lord, the case is, Lord, that
He is not fulfilling.
he is not eligible.
Promotional criteria is not fulfilled.
No, that criteria was satisfied only in the year 2017. So we appeared from 2018. Immediately, the next following year we appeared.
Lordship, that
Learned
is not-
single judge.
No, we are just asking, we're not conducting the memo. Give copy.
So we have given from 2018 onwards. Learned single judge.
Lord is saying, share a copy of the appeal
Just-
memo.
I just
Yes,
asked
Lord.
with
I-
the
no, I'm
party
sorry, I
person.
I assumed that copy would have been served.
Just
Lord,
to
we'll
know
serve it.
what is your case, just to, not.
Was duly served, but certain papers were
Lord,
missing.
we'll give him a copy.
Update that.
He is entitled for that. It is his right to ask, not, it is our duty to furnish, Lord, we'll furnish.
A small office objection which the office has raised, Your Honor, with respect to G1 and G2. G2 is the typed copy of G1, Your Lordship.
Page number.
One
Lord,
175.
G1 is a order which was in Hindi, and a translated copy was produced as G2. So they're one and the same.
Page number.
175 is the Hindi version, 178 is the English version. So G1 and G2 are effectively one and the same.
Side copy to be dispensed.
No, the office is now saying,
G2, as per the writ petition, what the learned party in person when makes the writ petition, he mentions that G1, G2 separately. But in the index, he says that G2 is the typed copy of G1.
So dispensed.
That objection has.
office objection may be overruled.
All office objections are deemed to have been completed.
Lordship, I have to make a submission.
Our copy of the.
Without the
memo
copy also, I just.
is supplied to party, learned party.
Take copy again. You will time.
Lord, there's a contempt petition.
Will be posted along with.
Along with this.
I think it's coming on third
It's
or
already
it may be
just-
posted along with that.
Fourth of
coming up
April.
on third.
I'm sorry.
Contempt is coming up on third.
Fourth of
Fourth,
April.
Fourth,
it's coming on
and this
fourth.
also fourth.
Fourth, ಸಾಯಂಕಾಲ. ನಿಮ್ಗ್ ಗೊತ್ತಾ contempt number? ಕೊಟ್ಟಿಲ್ವಾ?
Number 20, the Pratik Chandramoli.
It's on the last date of hearing. Lords are pleased to observe that let this matter be listed after. It's on the last date of hearing. Lords are pleased to observe that let the ongoing examination be concluded. It may render this appeal or the contempt unnecessary if they pass. The examinations are going on. The practicals are, my lords, to commence from next week. So lords may have. The examination is going on. Lords just indicated that if they pass, then all these become academic. Therefore, lords may consider calling this, my lords, after the second week of April.
Second April.
Number 21, say DV Shisha.
The appellant's counsel in this slide. The matter relates to resumption of land by KDB. Now subsequently, the land has been allotted to third party. We have made an application to implement the third party.
Well, the only issue pertains to refund of balance 5% of the amount. Lordship may see the last order sheet, my lord.
But in the interregnum, 95% of the amount has been received by the appellant. 5% is remaining, my lord. That is the only issue which your lordships will have to consider now.
I appear for the respondent number, seek to implement, my lords. I had also the balance 5%. I am ready to pay to the petitioner, to the appellant. And my lords, we can put a quietus to the litigation. Because I've already been allotted the land.
Please, remaining 2 crores is what is 35 crores has been received, my lord. 2 crores is what they're willing to pay us.
I have a demand draft, my understanding from KADB is that 1 crore 83 lakhs 13,614
Please.
is payable.
Please.
My lords, I have a demand draft for that. I have only one request.
That's the only grievance which we have.
Please, my lord.
Whether it comes from X, Y,
We are,
like in English law, we have no worry at all.
as long as the money is coming, my lord, we collect.
That's what.
Please.
Your Lordship may kindly see the last order sheet, my lord.
Implementing application has to be allowed now. It should be impleted. Then the implemented.
Order sheet, last order sheet. After hearing, my lord, the appellant said they're confining the writ appeal only to the extent of the payment of this balance.
5%.
5% of this amount, my lord. We have cancelled it and refunded their money.
Good. The the challenge in this intra-court appeal is two learned single judges order dated 8 January 2024 entered in WP number 23461 of 2023 GM KIDB. First stop. After service of notice, the first respondent is the respondent KIDB is represented by learned panel counsel, and the arguing counsel happens to be the learned advocate general. First stop. The petitioner appellant has moved an application seeking implement of the party named in the subject application as the respondent number 2, and there is unanimity at the bar that this application be allowed and permission to implead be granted. First, therefore, there is no need for much deliberation. Accordingly, application is allowed and appellant is permitted to implead the proposed respondent as second respondent. First, the the learned counsel appearing for the proposed the now impleaded respondent number 2 agrees to pay and accordingly has handed the bank draft dated so and so for a sum of rupees 1,83,13,619
614.
And that learned counsel appearing for the appellant fairly states that the grievance of her client has withered away fully with this. First, in view of the above, writ appeal is disposed of subject to realization of the bank draft consent ordered accordingly.
Obliged.
Number 22.
The appellant, please, Your Lordship.
Your Lordship had directed us to file synopsis.
Before this bench?
The earlier bench.
Earlier, it has to be heard.
To argue.
You have to argue.
We have to argue again.
Yes.
So nothing survives what happened. Yes, compensatory appointment.
Please, Your Lordship.
59.
I will also refresh my memory.
Whether the respondent, Your Lordship, is
Yes.
the respondent, Your Lordship, is the daughter of the deceased government employee. As on the date of death of the government employee, she was still married. And therefore, an application filed by her was rejected on the ground that married daughters were not entitled. Thereafter, she was before this honorable court. This honorable court said that in view of the judgments of various judgments that had come out in between, wherein married, divorced and widowed daughters were entitled for compassionate appointment, we should consider it on that ground. We reconsidered the application and we have rejected it on the ground that the application, which is based on the notification, Your Lordship may kindly take the notification, which is at page 55, Annexure E.
I had the privilege of sitting with the Honorable Justice Varali. One judgment we had, do you have a copy of that judgment with you?
No, please, Your Lordship, but I was.
Both have not seen that judgment.
But sir,
You have to see that judgment.
to read that news.
We have taken a little divergent view of, from yours.
Please.
That judgment you have to look into and come back.
But when the breadwinner died in this case?
Lords,
Please,
he dies, my lords,
my
on
siblings.
29/8/2019.
Which one?
29/8/2019. my lord.
Your Lordship, may kindly take my synopsis. I've set out the dates.
Just a few days.
Then, my lords,
Eight only.
Still she will be entitled to.
there is,
This aspect. has
there is
not
one more division bench order, my lords, passed by this honorable court. Lords, that I have placed along with my compilation.
dated.
Lords, that is dated, Lords, 13th of December 2023.
13th of December 23.
Please,
I was party to the.
no, my lords. This was, my lords, another coordinate bench, my lords. The view that was taken, my lords, is that once it is struck down or declared as unconstitutional, it operates, my lords, from the
Ab
date
inceptio.
relate back.
Ab inceptio.
Yes, my lords. Even in CBI, my lords, versus R.R. Kishore, the Honorable Supreme Court recently, my lords, has considered that view in the case of, my lords, Delhi police establishments.
What are your financial credentials?
My lords, financial credentials, my lords, they say that, my lords, I don't have any, my lords, other means except, my lords, the family pension and, my lords, the retirement benefits. They now say, my lords, that in view of that they did not, my lords, take that contention in the original
Compassion
endorsement.
all right. Compassionate appointment is
Yes.
only to those who deserve compassion.
My lords, in fact, my lords, in fact, that particular issue is concerned, my lords, except those, my lords, family pension and the
How much
emoluments.
family pension you are drawing? The object of giving compassionate
Yes.
appointment is to tide over the difficulty that arises because of the fall of the breadwinner.
My lords, that the rule.
I'll let you
present-
answer that.
Yes, my lords.
We'll come to that one. What is the family pension you are gaining periodically?
If I may.
Yes.
Lordship, may kindly take my
We'll
synopsis.
not, we're answering the
Your Lordship,
question.
38,340.
Family pension.
Yes.
Every month,
Yes,
38,340.
340.
Then terminal benefits
And-
were?
Your terminal benefits were 14,76,800.
This is only for those. It's an exception to the general rule of recruitment.
And the mother is also a
Amount
retired.
14 lakh and
14,76,800.
any
And the
property?
Your Lordship, but the mother is also a retired government employee.
She's
So
also retired.
She's getting separate. 25,150.
This is the married daughter you are saying,
No.
the earlier one.
No, Your Lordship, may kindly see, the family pension is 38,340.
To the widow, widow of the employee.
That is the family pension. The widow of the employee is drawing a pension of 25,150 separate.
The claim for a compassionate appointment is of whom?
Of the
Daughter of,
Daughter,
daughter.
divorced daughter.
Divorced daughter.
divorced daughter.
She is also drawing family pension. No.
No, she, even otherwise, if suppose she is to be taken into, the definition of family as per the 2021 amendment. Let us say that after divorce, she is staying with her parents. The family pension is there. And in the divorce petition, which may not be relevant, but I have to state so, she has said that she is financially capable of taking care of herself and did not seek for alimony. Because that is mentioned in one of the Supreme Court judgments, that their contention should be noted. I mentioned, and further regarding my learned friend's contention, that once it is quashed, it dates back. The Lordship may kindly see the rule clearly states it's from the date of notification that it will apply. So where is the question of it dating back to when the act came into force?
That rule is not put in challenge. That
Huh?
new rule.
New rule is not a challenge.
There is a direction, my lords, by this honorable court that they have to.
It says, judgment. Yes, Bhimesh. Yes. One view. Application is considered. What would be the legal position of this club? One judgment. Legal position from the date the application is considered. That may be subsequent also. Maybe subsequent. But if you are dependent upon application,
Open this one. The Lordship.
Your contention is she will not be a member of the family.
Family as on that date, as on the date of the amendment, please. And that has been considered by various Supreme Court judgment, which I have placed before your Lordship,
As of the date of amendment.
as on the date of amendment. And
Death also. Obviously, death also.
And the Lordships have held, the apex court, that the date of death should be taken into consideration, not the date of application and not the date of consideration of application, because those depend on various variables. This is the only consistent date is the date of death. So the rules as they exist as on the date of death of the government employee should be made applicable. That judgment I have placed before your Lordship. And they've taken into consideration the various earlier judgments.
That's
Santosh,
Bhimesh.
please, your
Bhimesh.
Lordship.
Bhimesh.
Oh, Bhimesh, yes, please. In my compilation, it's there.
The table is given of all.
The table of various judgments have been given.
So ultimately reconciliation is done saying that the policy which is less beneficial will apply. And forget all these things, Mr. Counsel.
Please.
By very concept, the married daughter may not become entitled to compensation. By very nature. Firstly, is out of the family, irrespective of being divorced.
Lords, may lords kindly consider the facts.
It
Lords.
can't be considered to be dependent.
Lords, only two set of facts, lords, that I would plead. Lords, 6/3/2017.
Smriti Kara say,
Yes.
Bharta Rakshati Yavane. The husband should look after the wife.
Lords, the proceedings, lords, for dissolution of marriage was initiated, lords, much prior to, lords, that is 2 years prior to the date of death of the father. And she was not residing with the husband. Later on, lords, after the death of, lords, the father, Then, my lords, the dissolution of marriage takes place. The consideration of application, my lords, is after, my lords, the law declared by this honorable court, my lords, quashing or, my lords, striking down, my lords, that particular provision.
That goes back to the
It
inception
goes
is
back to,
your
my lords,
leave.
the date that was, my lords, has been taken into consideration, strictly answered, my lords, by the division bench of this honorable court. The very issue, my lords. Even otherwise, my lords, there was an order earlier, my lords, passed by them that was quashed by this honorable court, specifically directing them, my lords, to consider under the new rules that they did not challenge, my lords. That order, my lords, they did not challenge. They accepted it to consider, my lords, under the new rules. Even otherwise, my lords, if the date of death, my lords, is not to be considered, my lords, there is a specific direction by this honorable court directing them, my lords, to consider under the new rules. They did not challenge that order. Now, my lords, they are taking, my lords, one or the other contentions, that is only to, my lords, reject. In fact, my lords, so far as the payment of terminal benefits, family benefits are concerned, my lords, the rule clearly says that has to be excluded. They did not reject it on that ground. Now, my lords, for the first time that they are raising it, that too in writ appeal. Kindly see, my lords, this is the third round of litigation. My lords, they have been, my lords, coming before this honorable court, my lords, with
But divorce was granted on 7/2/2020.
Lord 7/2/2020.
Death occurred in 2019.
2019. Lord's
August.
application, Lord's, is made on 28/2020. Then, Lord's, consideration takes place, Lord's, in 2022.
Another judgment also. There is one more judgment. I think that's also reported judgment, which we considered under one more judgment, I remember. That was more elaborate.
Lords, in Canara Bank versus Mahesh Kumar's case, Lords, in 2015, the Honorable Supreme Court, Lords, considers the very issue, Lords, that has been raised now to say that, Lords, the terminal benefits and the family pension, Lords, cannot be considered as a substitute. And ultimately, Lords, though, Lords, there is no such, Lords, provision which was available in that. Lords, in our rules, Lords, there is a specific provision which says that that has to be excluded by Rule 4.
While granting compassionate appointment.
Yes, my lords. My lords, I have placed on record. Kindly see, my lords, the Rule 4.
Canara Bank.
Yes, my lords. Canara Bank versus
Supreme
Mahesh
Court.
Kumar, my lords, the Honorable Supreme Court. Lords, that is the, in the compilation, my lords, last judgment. The only one sentence, my lords, that I would read from that, my lords, it is not that monetary benefit that would be replacement of the breadwinner, but they would undoubtedly bring some solace to the situation. Referring to so and so, the Honorable High Court has rightly held that the grant of family pension or payment of terminal benefits cannot be treated as a substitute for providing employment assistance.
Restated. So that she will devote to Northern family. Is not there, somebody said, I was what unknown things. Certain one of them. Sure.
Rule 4 says, my lords, that while calculating the monthly income, the income from family pension, lump sum pensionary benefits, and interest earned thereon shall be excluded. The rule itself says, my lords, they are bound by the rules.
Which is that the KCS rules.
My lords, 1996 rules, my lords, framed by the.
They are, you are university.
University.
Please, Your Lordship.
They are.
You have same rules or you have your
Same,
own
we
policy?
adopted. No, we don't have, but it comes
You
to.
have adopted.
Please, we've adopted. Yes, yes, sir. I believe your Lordship is referring to, this is Mega J versus Life Insurance Corporation.
Mega.
Please, this is the citation which, wherein they have said that the terminal benefits should be taken into consideration to see whether
No, that was under respondent was not state perhaps.
LIC.
LIC.
Yes.
Therefore, we said that way.
No, that is because LIC, they were not giving that compensation, but however.
No, they had given 1,58,00,000 to that lady. Therefore, we said you have a big purse with you, no question of hardship, etc.
Yes.
But if the rule says that the pension and terminal benefits shall not be reckoned while adjudging financial status of the lady concerned,
Please.
then we are bound by the rule only.
No, Your Lordship, which rule is this?
Rule 4,
And your Lordship. may
at page number
kindly-
14, lords, in my compilation.
Your Lordship may kindly take the amended rules. It says that all pending applications shall be considered as per the old rules.
Where is that?
Please, Your Lordship may kindly
7.
take page
7, the rule 7?
Page 59,
Yes, 7. Page 7, page
Please.
61,
Rule 7
7.
clearly states so. So the question of, that is
Was
what we have
declared as
stated.
unconstitutional.
That has not been declared
No,
unconstitutional.
no, not this one. My lords, under the earlier rules means, my lords.
No, no.
No, my lords, this,
6-1.
yes, my lords, this is 2021 rules, my lords, by which they say, my lords, that all applications, my lords, will have to be considered under the earlier rules. My lords, my submission is that as on the date of consideration, my lords.
So in
this-
respect of the pending applications, this is excluded.
This is excluded, all the benefits that
Expression
have
of
come.
this.
That is why, that's the endorsement that we have given.
What is sought to be done, my lords, by virtue of the present amendment is, my lords, giving effect to the order passed by this honorable court.
No, what is
Where, my
this?
lords, it says,
What does it rule 7 say?
lords, rule,
The appointment under these rules shall be made in accordance with the provisions that are prevailing on the date of application.
Application. That is in consonance with the Honorable Supreme Court's judgment. Justice M.R. Shah and,
So does it, does
as
it?
on the date of the application, my
no,
lords,
not application.
it says,
That is on date of death.
lords, that is what,
So in other words, these rules are made prospective.
This is made prospective
By virtue
and
of
your,
this, what
even
it says.
1, 2, Your Lordship, that also is clear, page 59. It says from the date of gazetting of the same. They shall come into force from the date of their final publication in the official gazette.
That is all right.
Please. So that was from 2/2/2021.
either way, my lords, my lords, come under the rules which was in existence, my lords, prior to the death of my lords, where, my lords, this honorable court, my lords, declare that particular provision which excluded, my lords, the married daughter and divorced daughter. My lords, since it is declared as unconstitutional, my lords, it goes back, my lords, to the date of, my lords, the framing of the rules itself. From that day onwards, my lords, that exclusion is not there. That is how, my lords, this honorable court has.
That is difficult to.
Lords, this is the, my lords, in fact, my lords, I am referring to the decision of the Honorable Supreme Court, my lords, where it says that CBI, my lords, case, that it goes back to, my lords, the date on which the order, my lords, legislation promulgated. And, my lords, even otherwise, under the compassionate ground appointment, there is an order, my lords.
Shirvai, in his 4th edition, discusses this aspect of the matter, where a law or instrument of law is struck down on the ground of legislative competence. Then it goes to ab inceptio date. If other than legislative competence, he says the striking down is from the effect of striking down.
Lords,
there is such a view by Shirvai. He has considered Michael Kirby of Australian High Court judge. His judgment he has followed and said that.
This has also
May I
been
just
dealt
point
with
out, my
your-
lords, one,
Sorry.
Hukum Chand, etc. versus Union
Correct.
of India.
There is one
1972
judgment,
to SCC
Which is the citation?
601. Please,
old judgment.
yes, 1972 to SCC 601. Paragraph
1972
11, Your Lordship, I have
2 SCC
two SCC
60.
601. Paragraph 11 is relevant. Your
Read,
Lordship.
read.
I have, in the case of the income tax officer LFP versus Pananus and others, this court dealt with the notification dated August 14, 1963, which empowered the revenue officials, including the Tashildar, to exercise the power of tax recovery officer under the Income Tax Act of 1961 in respect of arrears. The notification was given retrospective effect. Question which arose for determination before this, whether determination was whether the state government could invest the Tashildar with such powers retrospectively. Answering the question, the negative, this court observed, the parliament can delegate its legislative powers within the recognized limit, where any rule or regulation is made by any person or authority to whom such powers have been delegated by legislature, it may or may not be possible to make the same so as to give it retrospective operation. It will depend on the language employed in the statutory provision, which may in express terms or by necessary implication empower the authority concerned to make a rule or regulation with retrospective effect. But where no such language is found, it has been held that by the courts that persons or authority exercising subordinate legislative functions cannot make a rule or regulation or bylaw which can operate with retrospective
That's
effect.
not the question. Question is where the constitutional court strikes down law or instrument of law with effect from which it is striking down.
It will become effective.
If the striking down is on the ground of legislative competence, then it goes to the date of incorporation that the rule was promulgated. If it is other than legislative competence, the voiding of the rule is prospective in effect. This is rule-making power
And
of the delegate. What we are saying is a different principle.
Page
85 notes in my.
Because just Nagprasanna, Honorable Justice Nagprasanna has struck down that
Yes, my lord.
particular
Yes,
rule.
yes, my lord.
You are, therefore, you say it goes back to the first day of the
That's
rule
in fact, my
itself.
lords, the Constitution bench of the Honorable Supreme Court, my lords, in the recent decision, my lords, which I have placed on record at page number 85. The main question, my lords, that was placed before the Constitution bench, my lords, was with regard to when a law is declared, my lords, as unconstitutional, whether it operates retrospectively, my lords, as per Article 20. That was the main question.
How it is answered.
My lords, that was answered, my lords, considering, my lords, the various decisions at para number 43, my lords, it is observed that from the above discussions, it is crystal clear that once a law is declared to be unconstitutional, being violative of part 3, my lords, here also it is
Part 3
stated,
also.
yes, my lords, of the Constitution, then it would be held to be void ab initio, stillborn, unenforceable, and non-est in view of Article 13(2) of the Constitution and its interpretation by authoritative pronouncement. Thus, the declaration made by the Constitution bench in the case of so and so will have retrospective operation.
Correct.
But
falls
here also,
in-
my lords,
It
yes,
falls within what I have said only
Yes,
because
yes,
part 3, Article 13
yes.
injuncts the lawmaking authority not to make law.
Yes.
Therefore, no power to make law.
Yes.
Therefore,
Yes.
if any law is made contrary to provisions of part 3,
Part 3,
then such a law is void ab initio.
Yes.
Because of 13(1),
yes,
13(2), 13(1).
yes, my lords. In fact, my lords, the subsequent decisions also, my lords, considering the compassionate appointment itself in 2023 December, the coordinate bench, my lords, considers the very same issue and holds that, my lords, it operates retrospectively. My lords, even otherwise, my lords, my submission is Annexure C, my lords, may kindly be seen for a moment, my lords. Annexure C. My lords, these issues, my lords, need not be gone into for the simple reason, my lords, that there was a specific direction, my lords, positive direction that they shall consider under the new rules.
Which
That they
have
did not challenge.
challenged.
my lords.
Which they have not challenged.
They did not challenge.
Where is that? This
Lords,
court gave
Annexure
it.
C. Yes.
This court gave it.
Yes.
Yes, my lords. In the earlier round of litigation, my lords, when they rejected, when that endorsement, my lords, was set aside, my lords, at page number 46, my lords, it's page number 49, my lords, 48. Last, my lords, sentence. Accordingly, endorsement dated 14th of March 2022 issued by the respondent university is quashed.
9th April 2021, they have to
Yes, my
follow.
lords, yes. Now, my lords, the monetary benefit received, my lords, and other things are now sought to be raised in the appeal.
So thereafter, this impugn order is passed.
Yes, my lords.
May I make one?
Is not challenged by.
May I make, in that particular case, your lordship may kindly see the prayer. It was to consider. We have considered it.
Under which? What
Under the
regime?
21 and under 21, and we have
Light, yeah.
stated that she is not a dependent. The detailed order we have given after considering. Otherwise, it would have been that we did not consider because this amendment came about. Your lordship may kindly see what was the prayer. Because the, the application was made, your lordship. In the application, she said she was unmarried. That was the question before the learned single judge. Then his lordship said that merely because she has stated she is unmarried, you consider her because an amendment, this notification has come forth. Now I gave a detailed.
Madam, you are arguing an appeal against the order of 1st June 23. It's not.
No, but your lordship may kindly see that order.
See,
Please.
As my lord has already pointed out, you cannot argue against that order because you have not put any.
No, no, I am not.
Number
arguing.
one.
Please.
Number
Comes
one.
to that.
Actually, that. Number two,
Hmm.
after the divorce,
Please.
whether she will come back to the Natal family is unknown to Smritikaras because amongst Hindus,
Please.
divorce was unknown.
Please.
It was unknown institution. All that has come only subsequently.
Please.
But learned judge said in one judgment, a divorced daughter and an unmarried daughter for the purpose of compassionate appointment stand on par with each other.
Fair enough.
Merely because marriage happened,
Please.
she does not, should not suffer. After all, this meant for women upliftment. Perhaps
Absolutely.
we should have heard this matter on 8th of March.
Yes, no,
Not
but
today.
it's a continuing celebration, your lordship. That is not.
With that
Whole
statement.
point is, I would be
argument
going
should stop.
contrary to the apex court judgment, wherein their lordship, after considering everything, has stated that the date of death should be taken into consideration. So in every, first the
Who
notification.
says, sir? No, we cannot go to that, as my lord has already pointed out.
Please.
That the notification of 2020, which the learned judge said, under that you have to look into.
Yes.
That you have not challenged.
That is one, your lordship, but your lordship, how do I ask myself, how will I get over the apex court judgment? Which has stated clearly, which taking into the consideration this very rule, has stated that no, the date of death is what you should be considering and not the date of application. The notification says applications pending as per the old rule. Further, so in every which way, I would request your lordship to kindly have a look at my synopsis and then I leave it to your lordship. It's in the synopsis. I believe.
Judgment binds.
The-
Judgment binds. It's an inter-party.
But that was consideration. We have considered and rejected.
You should have, you could not have considered under other legal regime than what you were directed to follow.
No, they have not, the notification was not discussed at all. It was just said that this notification has come, I am entitled, let them consider. I considered it and have
Had
rejected it.
the law, my lords, had not been declared as unconstitutional, then, my lords, certainly they would have been right. My lords,
Has been
that was
declared as
missing, my lords, in the order of the Honorable Supreme Court.
Can I request your lordship to kindly
the order
make a
of-
note of
All
citations that
contentions.
I. Yes,
Little more contentions which have not been submitted at the bar also will be added.
it's all in my synopsis. I
Only
don't-
thing that the last order became trump card for us.
Yes, that becomes.
Hello?
Office subjections.
Why seventh time?
Please, my lord.
Seventh time.
Office subjections only typed copy of Annex B, my lord. It will be furnished. Since it is been sent to the office, main office, it is yet to be received. Insofar as this all furnished by the respondent number one in the writ petition.
So what do you want? You want to argue or you want time?
I will argue, I will submit.
You.
my lord.
Yes, my lords, I am ready, my lords. My IA 4 of 2024 is pending. It is to be considered for vacating the interim order passed by this honorable court, wherein the learned single judge had directed NHAI to deposit 100% of the compensation amounts, out of which I am permitted to withdraw 25% during the pendency of the writ petition. NHAI, being a beneficiary of the accusation, has challenged that equitable order, which my lords will get it at page number 21 of the writ appeal papers.
Appeal against interim order.
Yes, please, my lord.
Where is that order? Interim order? I could not.
At page number 21 of the writ appeal paper.
20. Sir, this is law. You deposited or not?
They have deposited, reported compliance.
25% is permitted to be withdrawn. That was challenged before this.
Why?
And this is, since the notification was on 13/3/2020. The next relevant first.
Ready to furnish bank guarantee.
Full amount will be released to you.
Yes, my lords, there shouldn't be any difficulty for us. Not bank, commercially, bank guarantee attracts 1% interest, my lords.
That happens.
That would be, if some, at least a 50% without bank guarantee, another 50% with bank guarantee may be equitable for my lord's consideration, which I am placing it for my lords.
Suppose if they succeed in the writ petition.
Yes.
How to get hold of, catch hold of the persons who have taken the money. There are agreeable points in the writ
I would
petition.
incur a running cost in the bank guarantee. Banks do level.
Naturally, if you want to.
It's
money, you
as
have to
good as
incur some-
borrowing the money, my lords. At least 25%, I would rather 25% may be ordered to be released.
So IA is right.
Poor farmer, my lords, to go get into this, maybe I leave it to my lords, but at the same time, it may become burdensome for the land loser, because prima facie case is made out
Because
by.
public money it is. As between the public money and the private money conflict, you know the law.
Lords, I leave it to my lords, at least 25% be released, and I will not press for 75%. I will not press for
That amount-
75%, I will wait for the outcome, because I am confident of succeeding in the main matter, wherein the.
If both you agree, we will request Learned Single just to hear and dispose of the matter itself. In similar matters, we have already adopted that pattern.
My lord, some money, I have to see the color of the money, my lords.
That you can see color, smell, everything you can see.
My
after
lords, I
petition
have to
is
see, my lords, whatever my lords find it equitable, my lords. At least. Poor farmers, they shouldn't be made to, but at the same time, if my lords were to hold the public doctrine, public interest doctrine. My lord, some readjustment of equities may kindly be made is what is my humble submission. Because the NHI's contention that it is a non-agricultural land. Notification itself says it's a non-agricultural land.
Preliminary notification was made in 2019. Thereafter, in 2020, 13/3/2020, they have got conversion official memorandum, and it was consented during 5th month of 2020.
When the preliminary notification was issued on which date?
24/4/2020.
This is a page number.
4/4/20.
2020, page number 104.
All right.
Date
When,
of conversion 13/3/2020. Much before the preliminary notification, not as sought to be pleaded in the writ appeal papers.
Page
And
268 may
thereafter-
kindly be, my lord.
And
This is the first gazette notification was published on 9th July 2019.
2019 itself.
19.
that
please,
is
my lord.
small 3A, they call small 3A, where a competent
It's
officer.
a bit different from acquisition under the Land Acquisition Act 1890, bit different.
Yes,
How Justice Sapre of Apex Court has held, treated that subject. Therefore, many other considerations will arise.
I have bought it and they considered my land to be non-agricultural.
Land Acquisition Act, there is preliminary notification. Then final notification. Then award position 16 to 15 variants. Beyond three.
Number 268, my lord.
2000. So immediately after coming, he has got it. No decision on this.
Already the matter was seized before the arbitrator, my lord, with regard to this question.
The embargo operates from big 3A, not from small.
Not earlier
3A,
to that
Not
one, yes.
earlier.
But
And
that,
the conversion-
no decision, I don't think that there is any decision of any high court on this point.
Not, my lord, I have done my research and it is, small 3A is only an appointing competent authority to take care of the acquisition. Embargo from creating encumbrance operates from section 3 capital A. My lords, without going into it, may I suggest one for the kind consideration of this honorable court? I may be permitted to withdraw 15% unconditional without compromising on the merits of the case. I can, I may make my.
What is the extent of variation? Suppose if the land is treated as agricultural,
It will
what
be
would have been the
One,
amount?
1 crore 19 lakhs is the amount.
1 crore 19 lakhs.
19 lakhs, my lord. And now
So
amount.
that amount you have to pay. Assuming that we will succeed in our writ appeal,
And agriculture land, what is the ratio of amount awarded?
My lord, they cannot go behind the preliminary notification which classifies it as non-agricultural money.
that the issue needs to be addressed.
What is annexure L?
Annexure L is a communication by which they interjected the whole process of determination of compensation by dictating to
page?
SLO
Page?
at page number 257. That's what I went to the writ court under those circumstances wherein they read
257.
257, my lord, annexure L. It's in small letters. I will try to read the relevant portion for my lord's kind consideration. The NHI being a beneficiary said, look, your award is not proper. You have not done the award properly.
257.
Yes, my lord. As per the paper book furnished, to me, it is
257.
257. My lord, you may help
Yes,
me
yes.
report all there is any. Yes, it is 257.
Annexure L, my lord.
My
This is how the
comparison
NHI.
Otherwise,
We are disposing.
In so far as
My
this,
lords, with a clause wherein, my lords, I may be permitted to withdraw at least the amount which has been subject to me giving bank guarantee to that extent. I shall give bank guarantee, my lord. I shall give bank guarantee because 2020 award
treating the land as agriculture land. That amount there.
For 19 lakh and that amount.
1 crore 19 lakhs is payable if the land is treated as agricultural.
Please, my lord, please.
With interest.
That amount you have to, with interest and other the
2020.
accompaniments.
29/9/2020 is the date of award.
This is the date of our SG. Date of 21. Yes.
They say that the SLA ought not to have determined the compensation by applying the principle of non-agricultural, even though the 3A notification considers and acknowledges it as non-agricultural.
You have said that twice now.
It is order dated 21/9/23. Passed in the writ petition number 7801 of 2022 by learned single judge, which is thought to be called in question in this writ of law, under section 4 of the Karnataka High Court Act 1961. By the said order, paragraph. Inter alia, the single judge directed the National Highway Authority of India, the appellant, original respondent, to deposit the amount as determined by the, what is SLAO? SLAO, what is the full form?
Special land.
Special Land Acquisition Officer. It is further directed that on deposit of the amount by the highway authority, the petitioner shall be entitled for release of 25% of said amount. In the writ petition, the respondent original petitioner has paragraph. Right to set aside the direction contained in order dated 4/8/21 by the passed by respondent 4, whereby the acquisition process was intercepted.
For National Highway.
What is this order?
This order is they directly,
4/8/21, whereby what is the purport of the order?
this is that they take objection to the determination of compensation by the award.
Was rejected,
No, they say that they don't grant approval. The,
whereby the.
yes,
whereby
National
the
Highway Authority of India
withdrawal of
asked the SLA
request
to
for withdrawal of
reconsider the
amount
award.
was Declined. Full stop. The another prayer made in the writ petition is to direct the respondent to disperse the awarded compensation of rupees 9,22,64,967 is in page 40 for the acquisition of this property in question. Full stop. When the order is interim order, the court is not inclined to entertain the appellate jurisdiction. The proper course would be to require the parties to reappear before the learned single judge, get their petition considered on merits. Full stop. Therefore, without expressing any opinion on the merit part of the controversy, in any respect, the parties are relegated, this court requests the learned single judge to dispose of the main writ proceedings within period of 2 months. The parties shall cooperate.
The arbitration process.
Order, it was stated that the amount is deposited.
Yes, well, it is deposited.
However, the other direction regarding release of the amount shall remain in abeyance to be subject to the final.
Because the learned single judge already decided that it decided 25% payment. My lords may consider.
Passed by petition.
My lord, so far as the disbursement is.
Why you drag us in the
No, my lord, so far as,
Main
so
procedure.
far as the disbursement is concerned, as my lord pointed out, at least to the sum which I am entitled to as per their own version may be released is my humble request to the honorable court.
That 1 crore 19
At
lakhs,
this
it will
stage,
be.
19 lakhs.
At this stage, learned advocate Mr.
V.V.
Learned
Shankara Narayana.
for the respondent requested that
1 crore 19 lakh,
that some amount
9,845. 1 crore 19 lakh, 9,845.
Yes, my lord.
Plus accompaniments, statutory accompaniments. That you have to pay.
Yes, my lord. Yes, my
My lord,
that part of the amount may be permitted to be released.
With the
Full
bank.
stop in this regard. It is to be stated that the amount of rupees 1,19,09,845 is the amount payable towards compensation.
As
If
per
the land
NHA
is to be
version.
treated as agricultural. Full stop. This amount in any case is an undisputed claim
1 crore and
to
what,
be
1 crore and annexure.
satisfied in favor of the petitioner. Full stop. Learned advocate. What is your good name? Yes, so and so and so.
What's your name, brother? Sagar.
my lord, in this matter,
Sagar Laddu state that.
my
amount
lord,
will be paid.
only may I make a statement, my lord.
The aforesaid amount, which is undisputed, shall be released in.
My lord, 1 crore is disputed amount, my lord. In this, according to the NHI, 12 lakh is amount coming for agricultural, my lord. I make
Whatever, Mr. Laddu, whatever
Madam,
amount is payable by treating the land as agricultural.
Yes,
Plus
ma'am.
statutory accompaniments, that
Yes.
you have to pay.
Yes, my lord. For that, we are ready to pay, but 1 crore is not coming amount. Inadvertently, that is the wrong statement.
You are disputing this amount?
Yes, my lord. 1 crore is disputing.
They should pay.
Annexure,
the,
1 crore 19 lakhs.
compensation treating the land as agricultural.
My lords, my
So
consider,
whatever they deem to be admitted amount.
my lord,
That they have to pay.
they consider my land to be agricultural land. In fact, the memorandum of appeal says so. At page number 9, memorandum of their own memorandum of appeal.
Treating your land to be
As
of status of
agricultural.
agriculture, whatever payable according to them with statutory
Accompaniments,
shall be
that
paid.
has to be paid.
My
We
lord,
don't, we will not specify.
My lord, in
amount we
spite of the
cannot-
preliminary notification saying it as non-agricultural, my lord, my humble submission
That
to
is the
this,
bone of contention in main matter.
my lord, may quantify it at least 15% of the
How
amount
can we
deposited.
quantify when we don't know? There is nothing admitted.
My lords, it will be the whole journey.
Then further, at this stage, learned advocate Mr. So and so requested the court to pass direction for release of part of the amount. Full stop. Having considered the said request, comma, the court permits the petitioner
Respond number 1.
file appropriate application before learned single judge, seeking disbursement of the amount which may be payable along with the statutory accompaniments.
That
If
takes
the
away
land
what
is
I,
to be,
that
if the
takes
land
away
is to
what,
be treated as agricultural.
that takes away what I got it for 2 minutes back, my lords. I got from the hands of this honorable court that they will deposit at least the agriculture part, whatever is admitted. But my humble submission to the honorable court is a kindly consider at least 25% the learned single judge has ordered.
Learned advocate for the National Highway Authority, Mr. Laddu.
Ladda, my lord.
Had stated that if such application is made, comma, the admitted amount with reference to the status of land to be agricultural land shall be calculated and shall be paid to the petitioner. With the aforesaid observations, the appeal is disposed of. Full stop. Parties shall cooperate before learned single.
I am grateful, my lord.
Great.
Sorry for sort of any inconvenience, my lord. That has been taxed.
number 23, Rajshekhar BG.
Complainant, please, my lord. Complainant.
Yes.
State has filed the affidavit. Lordship may please to see paragraph 3 of the affidavit.
Complied with.
Complied. It's not complied, my lord. For a moment, Lordship may please to see paragraph 3 of the page 3 of the affidavit filed by
Whatever
the
the direction.
Direction was for consideration.
But this is a case wherein, Lord, the police their allegation is that the jurisdiction of police are interfering with the activities, and last week it has come up.
Which is the matter other day we disposed of that matter. You had argued other day, similar matter. Which is that order? That we will print that order here, identical facts.
Police reading.
Police reading this.
Paragraph 3, my lord, they say that credible information made them to visit my club for 4 days, 4 times in a week. What is that credible information? They should
What is that?
disclose
How
it to
many
my
times?
lordship.
No, where is the restriction as to number of visits?
My lord, I don't say, my lord, that I have followed the rules, regulation, direction given by the learned single judge, ordered by the learned.
We have already considered and rejected that argument in another matter.
Lordship, photograph may kindly be seen. They are not one, they come in group.
Which law says the policeman should come lonely?
My lord, my humble submission is.
They decide.
I'm
how many
not able
people
to
should
run my
go.
concern.
These are all left to the decisions of the executive.
I have
We cannot say which uniform, what is the number of the personnel. These are left to the pragmatics of the police station. How can we decide? How they will know how many people have gathered there? What is the nature of those people? How many of them are leviathans and believers?
Let them visit, my lord. They have taken away my footage, CCTV. They have threatened my employees. They do not allow my members to get into the premises. That is what the allegation, that is what the averment of the complaint, my lord.
In the writ petition, where the dispute was with regard to the obtaining of license by the petitioner in relation to the recreation activities the petitioner has been carrying on, from allowing a single judge dispose of the petition by issuing the following operative directions. And page 19, A2G, long directions. So where is the compliance? What, something is filed?
Yes, ma'am. On 14th March 2024, we have filed an affidavit.
13th March.
14th March.
14th, 13th.
13-3.
13th was filed.
So paragraph 3 may kindly be seen.
When the aforesaid directions were sought to be complied with by filing the present contempt proceedings, respondent state to learned government advocate Mr. S.S. Mahindra filed affidavit. Detailing the instructions given to the police officers regarding the manner of visiting and inspecting the premises of the, correct?
And credible information they have visited and instructed the manager.
And only upon the availability of the credible information, the steps in accordance with law shall be taken. Full stop. The aforesaid affidavit and the contents thereof marks due compliance of the directions of learned single judge. In that view, no further orders are required in this contempt proceeding. It is, the proceedings are closed and disposed. Obliged.
Number 24 is Smita RB.
Your lordships may kindly turn to page 18, the learned single judge's order. The relevant portion at 26.
Page 80.
18 is the learned single judge's order. The relevant portion is at 26.
This is what again contempt. Yes.
Lords, the learned single judge, while quashing the demand notice raised by the panchayat, directs them to refund the amount that I had deposited with them with a direction to repay it within 8 months.
Who will appeal? Notice is to the heard
Yes, my
learned
lord.
advocate Miss Anupama. No. What is your name?
Smita. Smita RB.
For the complainant notice. Discernible.
My lord, another submission. There is an office
15th of April, yeah.
objection raised that the accused here is the town panchayat, which was formerly the Gram Panchayat. The Gram Panchayat was integrated into the town panchayat. Consequently, they are shown as the accused. That may also be.
Makes no difference.
There was an office objection raised, which hence the submission.
Wherever it is. So we feel to be the same. Yes.
So whoever chair will step into
They
this.
step into this section itself.
Number 25. Bill by Goma.
My lord, the serial number is 57 is a relevant, my lord. The subsequent, this 25 is comes. 57, my lord.
What is?
My lord, it's a fact of the case, my lord, that there's Wajaralli village survey number 79. There was acquisition land by the land acquisition officer. And subsequently, my lord, during the pendency of this acquisition land, the notification issued by the state government. During that pendency of that acquisition notice, that the Lakshmama who was subsequently sold the property to Justice to the Sohail. So after purchasing the property by the Sohail, suppressing the fact and filed a writ petition before the learned single judge and quashing the notification. So that there is a Supreme Court judgment, my lord, that the once acquisition notice is a pending and it should not be subsequent to sale of the property.
At what stage sale took place?
During the pendency of the acquisition notice, then the landowner was sold the property to the Sohail.
To Suhail.
Sohail.
Petitioner, writ petitioner.
Yeah, please, my lord. So that is in 25, the 25 who purchased the property. The serial number 25 purchased the property, 57 is original owner of the property. And based on this, the suppressing the fact of the case, my lord, subsequently they have obtained the order from the High Court and made the Chief Secretary to initiate the proceedings.
Amendment to which act I do not know, which says if land is within the territorial jurisdiction of corporation and if it is notified, no transaction shall take effect. In
Yes,
respect,
please.
which is that act?
It is 1991 act.
There was one such act.
91. 1991.
It says, where land is notified, nobody shall transact.
Where is the impugn order? 26 page.
21.
It is prohibition on transfer of lands acquired by government.
Where is the order impugned in the petition?
My lord, Chief.
The order impugned in the writ petition.
The writ petition, my lord, the page number in serial number the 57, my lord, page number. If lordship taken the 57, it will be grateful.
57. That is the order dated 26/7/22.
Please, my lord.
Which page you said, Mr. Learned AG?
My lord, the
7.
page number 13, serial number 57 case, my lord. 13.
Page 13.
My lord, the order is commenced is a page number 9 onwards, my lord.
Where is the order dated 26/7/2022?
That is, my lord, in writ petition number 13, my lord.
30.
13, my lord.
Cannot be 13 because the order, the impugned order itself runs. Your appeal itself is 12 pages. In the writ petition,
No, which
a
we-
particular order was challenged.
My humble submission, my lord, which writ appeal my lordship has pursuing so that I can answer. The writ petition.
308 of 24.
That is at page number 13, your lord.
13.
Order is,
Page
at
number 13, ma'am.
13, your lord. Writ appeal 308 of 24, to page number 30. the
Page
order-
number,
One
page
three.
number 13 is the order with which that single judge's reasoning start, the judgment starts.
Yes,
Yes,
your lord.
please.
We are asking the order dated 26/7/2022 at an L to the writ petition. Where is that order?
There is no. That is at page number 146.
146, my lord.
In which writ appeal?
It's a 308, my lord. 308 of 24, my lord.
308.
It is a learned single judge's order.
Please, my lord.
But the order which you have referred to, Deputy Commissioner,
Lordship, may I make one, I elucidate your lord. At first instance, your lordship, if we take up writ appeal 405, it
Yes.
would be good, your lordship. So that it will 405, your lordship.
what was challenged in the writ petition?
Acquisition, your lordship.
Acquisition.
Acquisition, your lordship. The pleading of the writ petition at page number 17, your lordship.
Why two writ appeals?
What happened, your lordship, here, this writ petition, in this writ petition, the landowner who comes before this court and obtains an order. The landowner executes his sale deed in favor of one H.A. Suhail, who is in whose order we are assailing in another writ petition, your lordship, another writ appeal.
Justice Suraj Govindraj's order.
Yes, two orders are there, your lordship.
After sale, what happens?
She comes before the court, he executes the sale deed on 23/3/2019, and she prefers a writ petition on 1/6/2020, suppressing that she has executed the sale deed. And she comes before the court and she obtains the order where the honorable single judge has quashed the acquisition notification.
On the ground that his name did not figure in the.
Not that it is covered by judgment, quash ಮಾಡ್ತಾರೆ. It is nothing has been precisely dealt with the case. It has been ಅದು order ಅಲ್ಲಿ ಹೇಳಿದ್ರು. It covered by judgment ಅಂತ ಹೇಳಿ that land acquisition has been quashed. Later, the subsequent purchaser surfaces. Till then, he doesn't come before the court. Then he comes before the court. In between, he makes an application for the conversion. Conversion was rejected on certain grounds.
That legislation was not argued before the court.
It was submitted, your lordship.
91 legislation.
See, the whole thing came to our knowledge when we were arguing the matter of 18/313.
So
That-
deemed
that was-
conversion takes place after 2 months.
4 months.
4
But
months.
that will not arise because there is prohibition, statutory prohibition.
Statutory prohibition is there.
Special act is there. Which is that act? Do you have copy of the act with you?
Yes, your lordship. That we have annexed. Which one, your lordship? That-
91 Act.
91 Act, we have made the compilation of the judgment. The judgment itself is there, your lordship, in regard.
No, there is a 1991
91,
legislation
yes. Adu book,
which prohibits, once land is notified, the transacting with that land is, there is an absolute embargo.
yes, your lordship. Karnataka Land Restriction on Transfer Act 1991.
91
Section
Act.
3, prohibition on transfer of lands acquired by government. No person shall purport to transfer by sale, mortgage, gift, lease or otherwise any land or part thereof situated at any urban area which has been acquired by the government under the Land Acquisition Act or any other law providing for acquisition of the land for the public purpose. On this court has passed an order and levied 1 lakh rupees penalty in writ appeal 3897 of 2019, your lordship. The crux of the case is that, your lordship, landowner comes before the court after executing the sale deed, she suppresses that, she obtains an order, then subsequent purchaser surfaces before the court, he makes an application before the DC, it got rejected, suppressing the thing, he comes before the court. Again, when we were arguing the third round of the writ petition, we came to know that he has suppressed.
So both is first time it is, yes. So 308, writ appeal 24 and both 405 24.
Yes, your.
Common order is under challenge.
Not common order, different order.
So in both the appeals are interactive on facts and in respect of the issues involved. First of heard learned
Age.
Additional advocates.
learned additional advocate general, so and so, so and so, so and
Yes,
so.
sir.
For the appellants in the respective appeals, notice to the other side, returnable on 19th April.
Much obliged.
In the meantime, not in the meantime, in the facts and circumstances case by a paid entry in lieu, it is directed that the so order in 308 only will stay.
So both it has to be tested.
Both.
405 is the basis, your lordship.
No. 405, what is the order?
405 is by the basis of this or another.
405 is the basis, your lord.
This order.
In the facts and circumstances case, there shall be aid entry in writ appeal number 30824.
405.
By directing that the impugn order dated 31st August 23, passed by a single judge, and impugn in the appeal shall remain state.
Yes, sir.
Till the next date.
And also 405.
The other appeal,
405.
number 405 of 24. The order impugned is the basis of the order passed in the companion appeal. Therefore, the said order dated so and so, so and so. That is 1st July 2020 shall also remain state. Till
Yes.
the next.
Now what they are doing, the lordship, after Shivkumar's case, earlier Manava Dharma case was there, where subsequent purchaser has a locus standi to assert. After this, now they have developed a modus operandi. Now landowner comes, they take landowner and they make the writ petition, they obtain the order, then they are coming before the court, your lordship. That is
Modus operandi to get lend, get back.
much obliged.
December 26, Anish Jose.
The correspondent before the report is before my lordship. Lord, the brief facts of the case is that the writ petition has approached this honorable court seeking waiver of interest and also for staying the auction. This honorable court, in page number 17, my lords, by the order dated 2/9/2022, had granted an interim order of stay on a condition that the writ petition is paying 25% of the outstanding amount. That need to be paid in a period of 5 weeks, 2 weeks, 2 weeks plus 1 week. It's the order passed by one of my lordship justice. And the learned single judge, my lordship had also made it clear that the order is not complied. Not only the interim order stands resigned, but the writ petition itself runs the risk of being rejected. The interim order has to be complied by 15/3/2022. On 4/4/2022, the writ petitioner approached the respondent and paid 4,18,000 in one of the account and released the gold articles pledged in that account. Thereafter, my lords.
Surface proceedings.
No, my lords, it was a gold loan plus pledged. It was a gold loan taken, my lords, not surface. The writ petition has taken 3 loan accounts, my lords. And afterwards, what happened is that since there was non-compliance of order, on 30/6/2022, the respondent before the writ court has auctioned the golds which has been pledged in the 2 accounts.
All right, learned single judge says,
yes,
the claim has to be processed by appropriate authority.
I am
And
the
the amount
respondent.
whichever you have deposited is liable to be returned.
I am the respondent here.
You are the respondent.
Yes, my lords. Here what happens is that actually the loan has been waived off by the learned single judge. The amount auctioned is directed to be returned to the writ petitioner. In addition to that, the original gold which was pledged was also been directed to be returned. Ineffectively, the writ petitioner is getting the gold plus the 25 lakhs which I deposited, also the gold taken.
Initial state. Under which act all these proceedings arose?
My lord, it's a purely contract transaction, my lord.
Pure contract.
So it's a contract transaction. Surface proceedings or nothing is involved in that. Arbitration clause is also there in the agreement. Since the translation copies is not available, I'm not going to ask for the consideration of interim relief. I'm not going to all those things. But here what happens is that, my lord, they have taken a loan of more than 20 lakhs. They defaulted it. On the date of the order, they're supposed to pay around 27 lakhs. They are not paid. The auction has been taken place. 24 lakh, some 40,000 has been received. Since the writ court has ordered us to direct it to be deposited before the registry of this honorable court, we deposited that. Now, by way of impugned order, that amount has to be released to the petition. In addition to that, the gold which they all pledged has also to be, or the equivalent has to be also be returned. The loan which they have taken is ineffectively waived off.
Contract.
You are the original petitioner.
Now, my lords, I am the respondent before the writ petition. I am the financial institution. In the when the writ petition itself is not maintainable.
This is what exactly we are discussing.
Yes.
Lord learned advocate. So and so for the appellant original respondent. Original response.
Petition.
Appeal is admitted. There shall be stay of the impugned
Much obliged.
to operate during dependency of the.
My lords, 2 weeks may be granted for furnishing the translation.
All of his objections shall be removed within 3 weeks.
Much obliged.
27.
My lords, appearing for the petitioner, my lords. My lords, I had challenged the auction. My lords. My lords, I'm appearing for the petitioner, my lords. I had challenged the auction proceedings, which were scheduled to be conducted on 16/3 of this month, my lords. The writ petition has become infructuous, my lords. I may
Honorary
be
Advocate
permitted
Ms.
to
So and
file
so and so stated that
Name.
in view of what?
to file a fresh writ petition.
This is what? That the writ petition has become infectious. In that regard, she tenders memo of withdrawal dated 18/3/24. Wherein it is stated that the auction has already taken place
Please, my lords.
on 16/3/24, rendering the subject matter of infectious. Full stop. The petition is disposed of
With the liberty to file a fresh petition, my lords.
accordingly. Full stop. Liberty is available to the petitioner to file fresh petition. It could be filed on availability of cause of action and in accordance with and the law permits.
Actually, that's too late. What have not seen.
In this, the state has preferred an application. This is a writ petition
Acts or
PIL, my
necessary
lords.
minutes before the consideration of the
May I
application.
submit, my lords? This is an application filed by the state. In
Background,
this PIL, my
no,
lords, there
background
are
of the case may be necessary minutes. Can I just state that?
Application civil.
And the background of
Here
the
you
case.
also.
No,
Here
back-
you also.
My lords, in this certain amounts are deposited under this PIL, my lords, by the company that is respondent number 12. And the monies are directed to be utilized for the people of that area, my lords. For that, when, as and when the state government decides any proposal, my lords, we are directed to seek permission from this honorable court for release of that amounts. My lords, on 16/6/2023, my lords, we had filed a similar application and this honorable court was pleased to release an amount of 8 crores and odd, my lords. In that, we had filed an application seeking construction of a primary health center and a school, my lords, in survey number 58 of Golla.
This amount is deposited by? other
By
than-
the company, my lords, L&T company, which was one of the respondents.
Towards,
Towards the 2% of its sale consideration, my lords, which is for the development of that area. My lord, survey number 58, my lords, in Golhalli village, Bangalore South Taluk, this honorable court gave us the permission, my lords, to withdraw the amount to an extent of 8 crores. My lords, when we started the construction, my lords, we came to know that the property, my lords, it's actually an old quarry unit and there were landfills. And we dig it further, my lords, where we took the opinion of the technical experts and they told us almost 3 crores extra will have to be spent on this project. Hence, the government decided, my lords, identified another 2 survey numbers just adjacent, my lord, survey number 21 and survey number 156. For construction of the said primary health center and the school. Now we are just seeking a modification of the order of 16th, my lords, to modify
Instead of
the
putting up construction there, you will put construction.
the same village, my lords, in the next survey number, because that,
How much, what is the distance between earlier landfill and the present land identified?
that I will, my lords. I'll let me, it's the same village, my lords, I'll see the distance, my lords.
My lords, the health center is 1 kilometer away from the existing survey number, and the school, my lords, is 3 kilometer away from the old survey number, my lords, for which permission was granted.
So fund will be used only.
Yes,
that
only
purpose
for that, only for that.
Location
purpose.
is changed.
Location is changed.
Let us see.
May I please? Now, the respondent number 8 is a popular Bollywood star, and he and his family, they purchased certain agricultural lands that came to be questioned. Large extent of agricultural land came to be purchased, and that came to be questioned in a public interest litigation, contending that he could not have purchased agricultural land in Karnataka as there was a prohibition. Then, writ petition was filed in the year 1996. Unfortunately, there was no interim order, and it was taken up for final hearing in 1999. The court then felt the objection raised is correct, but since the building has come up, a novel method was adopted by which the court said, instead of collecting the regular stamp duty, we will direct collection of 2% more of stamp duty in respect of every property that is purchased in that the project. That's so and it also said the writ petition will always be on records before this honorable court. It will never be disposed. And my lord could kindly see the order passed on 24/9/2012. This has been referred to therein. By way of recapitulation, my lord could get it means.
Twenty-four 9/2012.
Well, your lordships, right, means.
By way of recapitulation.
We state that the subject matter of this petition was for sale of agricultural land for the purpose of setting up residential apartment in South City. By the time the final order came to be passed, it was observed that the structures had already been completed, and therefore it would be idle and wastage of money to order demolition thereof. Instead, the court devised a novel scheme by which a sum equivalent to 2% on each sale transaction in the said layout would have to be deposited in a special fund. This 2% was in addition to the normal prescribed stamp duty and registration charges that were attracted in all these transactions. Up to 31/3/12, a total sum of rupees 14,51,42,000 has accumulated in this fund. The question that has then arisen is what would be the most productive manner in which these funds could be used. It was considered appropriate by all parties concerned, and taking cognizance of all inputs, public projects in the environs of the layout should be preferred. Please note, in the environs of the layout should be preferred. After several hearings, the following projects were cleared. Earlier to that, this order was passed on 13/4/2012. We have perused the orders dated 13/4/99 and are in no manner of doubt that collection of 2% on transaction was not intended to be used for rehabilitation of encroachers on Puttenhalli Lake. Restoring lakes to their original state by removing encroachers therefrom is one of the primary duties of the state. All expenses must come from the state coffers. We expect that proposals and plans for construction of hospital or such as pointedly envisaged in the said order shall be available within the next 4 months. Then, this honorable court directed that the matters be placed before the Lokayukta. Lokayukta could go into all these aspects, whether the construction is coming properly or not. All those issues were directed to be gone into. Now, they are seeking for a change. If it is within the same locality, I cannot have any objection. Otherwise, the matter goes to the against the law and the principle laid down in the first order. That's what I wanted to highlight. If they say it is in that very location, because it was meant for the use of the villagers, because their village lands were taken away and a building has, a concrete jungle has come there. That's what this honorable court observed on that day. First, this honorable court itself was monitoring all the case minute. Then Lokayukta was requested to look into the matter. In the order dated 13.
This application could have been made before The Honorable Lokayukta.
They say in the application that they have made an application and the Lokayukta has not passed any order, but directed them to approach this honorable.
We say so in our affidavit, my lords.
We can request the Lokayukta to pass order on this application because the order he is directed to monitor the construction activity and to ensure proper utilization of the amount.
Annexure R6, my lords, the communication of Lokayukta.
We can
Para
if-
8, my lords, we have
No,
approached.
we want to know if
Lokayukta is
both
given the
you are
power, I have no
agreeable,
objections.
both you are agreeable, where Lokayukta will have the power to get more inputs than us in deciding this. If both of you agree.
Yes, ma'am. Yes, ma'am.
Perhaps,
From my side, absolutely no objections.
You want to take instructions or you're agreeing?
I'll take instructions.
Take instructions. Better you take. Oh.
And my colleague's name may be shown to be in the class list. I'm sorry, my.
Name of Madam.
Next week,
Next Monday, my lords.
Monday, 25th.
We also say. Comes out from this, yes, that's right. Especially when you find
So despite the institution of Lokpal, so many PIs.
Please, Your Lordship.
Grateful, my lords.
Please, Your Lordship, come follow your lordships.
No,
Despite the institution of Lokpal functioning,
Yes.
why you people filing so many PIs?
This was in 96 minutes.
No, no, not this, generally.
PIS.
That the order from this honorable court has real effect than the other orders. In fact, unfortunately, even orders of this honorable court is being neglected. In fact, I had some questions also on that, especially on the road construction and footpath occupation. There are some directions.
Because
but
many such petitions require investigative exercise, which
True,
we are
yes.
able to, and we don't want to do it. That way.
But some of the petitions also, they also lose interest of some time. They say we will
Right,
not
yeah.
come and we cannot substitute for them.
Yes, this is, we are not on this, yes.
True, yes.
Number 29. M.V. Sundar Raman.
Waiting for the petitioner in this matter, my lord. The last date of occasion, the counsel for responding that is state had to provide a report of inquiry in sealed covers, my lord. That was the
Regarding?
direction given.
Regarding what?
Regarding layout, my lord.
That-
Cooperative society.
My lord, that has been complied with, my lord, on 29 January 2024, my lord, I have placed it in a sealed cover.
We haven't
Last
got
case, my
copies.
lords, respondent number 1 and 2 are the corporate, is a cooperative society. This honorable court directed, my lords, an inquiry be held by the registrar of cooperative societies and to file a report. And the report is now placed before your lordships in a sealed cover. Your lordships on the last occasion are directed that the sealed cover would be given to all of us. A copy of the report is given to all of us. That has not been done. It's still in the sealed cover.
Report of inquiry. ma'am.
The inquiry has already been completed and the report is.
So sorry.
That order was passed.
Yes, please, my lords.
With order dated
Last week.
29.
15.
15. Oh, which one?
15 January.
1512.
12.
1512. This is the order. 1512. Yeah.
In 221.
That's the early order
Ah.
of constituting the committee. The
But the order which your lordships passed last time was to direct the government to file it.
Well, that order was 10th February 2021.
No, that's the earlier order.
Yes.
Ten to 21. 10th of February 21. Of course, the longer order, my lord, is on 12/9/2019. If my lords take 12/9/2019, not para 9 of order.
To place it in the sealed cover, my lords, it was on 10/2/21.
No, no. The order directing
Yeah.
inquiry.
Place it in the sealed
Yes.
cover.
That's
Why 9/2019?
no, no, 12/9.
12/9.
12/9. That's a fairly long order, my lord. 12/9. Para 9 of that order of 12/9.
Not getting the order.
We direct Registrar of Cooperative Societies
To decide whether he desires to initiate a suo motu inquiry under subsection 1 of section 64 of the said Act of 1959. He shall take a decision within a period of 1 month on which the documents are directed as directed above are submitted by the petitioners. If the registrar comes to the conclusion that there is no necessity of initiating suo motu inquiry under subsection 1 of section 64, he is expected to record his reasons for coming to the said conclusion so that the same can be tested by this court. Then Lord, he said he will inquire, and therefore a time was fixed on 10/2/21 to do that process.
What he decided?
That he decided to do a suo motu inquiry.
He decided to go for inquiry.
Inquiry. And therefore the court not said file that in a sealed cover.
That inquiry proceedings were held.
Were held, my lord. I'm not very certain how far it went
Yes,
in terms
yes,
of
it was held.
recording statements of all parties.
Yes, it was held.
So accordingly, inquiry was held and you all participated in the inquiry
Yes,
also.
To some
But
extent,
the outcome of the inquiry is section 64, cooperative societies. and
Yes,
cooperative
please, yes,
societies.
please.
What
that report is in a sealed cover before I understand. Lord. We've
Yes.
not been informed of it.
It's.
You did not get the reports.
We've
No,
not got the reports.
None of us.
What is there in that sealed cover? 64 inquiry is a public inquiry.
I think at that point in time, not a request was made by one of the councils appearing that let it be in a sealed cover till it reaches the court. And then the
We seal government product.
Sealed cover. It's impossible to put.
So nobody of you requested to open the seal.
Lord, I didn't even know it's been filed, my lord, because even on the last occasion, my lord, when the matter came up before my lords, there was a request that they at least file it before the court.
Report
Now
is
it's
said-
come.
Report is said that nobody likes content of it.
We are afraid to open it.
Please
Like
open it.
Nanika Sanduk.
Your lordship may permit us to also examine it, my lord.
We can open it. It is portion we have to share with.
Yes.
64 inquiry is, it's held in Puttegoda's case, that is a discipline, it's a quasi judicial proceeding.
Quasi-judicial.
Request judicial.
Against director.
I beg your pardon, my lord?
Office bearers.
Office bearers, my lord. Office bearers of the
Cooperative
society.
society. Registered.
Then nothing private, nothing confidential.
No, nothing
Public
confidential.
inquiry.
So on the basis of this report, there will be further action.
There should be further action now.
68 order needs, order under section
Surcharge
68.
proceedings. it will-
If say 69 or order under section 68 needs to.
On the basis of this.
I hope the translation of this. Kannada na.
I don't know.
I know. They filed it in Kannada. Again. I think that was, there's another bigger cover there.
There's one more cover.
He has held some are guilty, some are not guilty.
Why, sir?
At least take this copy of the order.
Yes, ma'am.
Report we have to share. Even going by Ramjan Khan case, which is held applicable to this case also.
Was not. Now even Supreme Court says don't give us anything in a sealed cover.
So that they can come out. What follows from this? This is 64 inquiry.
But even after. But I was asked to place the report before my lords. And
Even
there
you,
are-
you also do not know.
I don't know, my lord.
These are all volumes of the report.
Yes. Only.
No, I think those must be the documents, my lord.
Documents which
They
we
have
must have,
Documents in support.
Proceedings.
we must have submitted some documents, my lords. Those must
But
be. the
whatever was filed, I got it filed, my lord.
That's all right.
Yes.
But we need not retain the method. Let them go back. And the copy of the report shall be shared with them. Further process. It should go to this registrar. Who is that registrar? Whoever, whichever registrar held this inquiry, to whom this document should go back for further action. From 64, it travels to 68.
Yes.
An order needs to be passed. What is to be done further? He has to examine this and pass an order under section 68, my lord.
68 it has
Yes,
to travel to.
he has to give them time for compliance and he has to, if there is anything need that can be done, my lords, it will be done.
With that direction, perhaps rest of the things, he has to do it under section 68. We cannot monitor that.
Maybe first look at the report before your lordships.
Huh?
Maybe
Report
first
after.
look at the report before if you have anything to say, my lord, on the report, we'll just make some.
Report will give you. There is nothing like keeping the report discreet at all.
Yes.
It is, there is nothing, but rest of the things, why we should keep this matter pending, we do not understand. Because the law is, right from Justice Humbegoda's time, if 64 inquiry takes place, then it should travel to 68, this way or that way, surcharge proceeding. Why court should monitor all those things?
But there's a reason, of course, in this matter, my lord, why this was, of course, had such a long
Checkered
history.
history.
It's a checkered history of a bit, order being passed, reviewed, then placed back before your lordships.
Even then, this stage will be a premature stage.
That's what.
Beg your pardon, my lord?
This will be premature stage
Whatever
for
may be
us,
checkered
for our
history.
interference.
No, in the sense, checkered history, in the sense, in this litigation, what has actually happened, my lord, was there was an order passed with respect to, my lord, return of certain sites. Because all of this, my lord, relates to land acquired for the purposes of a society called a judicial house building cooperative society. My lord, and the allegations, my lord, are that a lot of acquired land was misused for other purposes other than the purpose for which it was acquired. And a lot of material was placed before the court, most of which was admitted. The court, my lord, in this case, what happened was actually the writ petition was allowed.
It was recorded in order dated 10/2/21. Today, when the proceedings came up for consideration, it was noticed that the report was submitted by the inquiry officer and was placed in the sealed cover in the record of the court. Full stop. In the presence of the learned to the parties, the sealed cover was directed to be opened. The court officer, full stop. The report was seen by the court. Paragraph. Let the parties have the benefit of the contents of the report. The registry shall make available.
The registrar, which registrar held this?
The content of the record shall be, the copy of the report may be available to the respective parties by.
Is it JRCS?
No, my lord, it is the registrar.
It's.
Registrar of Cooperatives.
Registrar of
Additional,
cooperative.
additional registrar.
Additional
of
Additional
cooperative
register of the
society.
Yes,
cooperative
yes.
societies. Bengaluru,
Bangalore.
Alex Karod.
Bengaluru.
within 1 week. Within 1 week, you see that
My lord, the report is before my lord.
you need entire award of this operative.
I'm not certain, but at least
4 weeks.
Or-
4 weeks.
This to be replied.
Also, the original copies of the report and the volumes attached thereto shall be returned to the additional government to be forwarded back to the competent authority.
Lordship may retain this copy, my lord, because there's something which may have a bearing on this case. The reason why the order was passed was to ensure, my lord, to find out if there's any illegality which your lordships may have to examine. Therefore, let the,
What we can keep.
no, let this, I would
The
humbly
report
request,
we
my
can
lord,
keep.
lordship may retain the record for now.
The record.
After, my lord, we've seen it, we'll make a submission as to whether it should be returned or not.
But then how will be able to get the copy? You must have copy additional.
No, my lord.
Why? You
My
must
lord,
have
because there was a
the
direction,
sealed cover.
a sealed cover.
We'll
Yeah.
take copies, my lord, lordship may direct the registry to issue certified copies. my lord.
Your own cost. and your-
Yes, yes, on our cost, yes, on our cost.
So then write down such a way that parties are at liberty to obtain the copies of the report from the registry of this
Right.
court by paying the necessary charges.
Yes,
Please, please.
All the report and the volumes which are part of the report, documents which are part of the report shall be retained in the record of the court by the court office.
Registry.
Registry, man.
Keeping the same in the safe place, in the safe custody. Safe custody.
yes.
Register judicial.
Register judicial. Register judicial is directed to keep the report and the documents, public volumes, which are part of the report, in safe custody. To be made available on the day when the proceedings are next list.
Very good.
So we shall keep it on 23rd April.
Yes.
Yes, please.
At early.
Yes.
You read the report, but not to argue the case. To argue. When shall we keep?
23rd, we'll make some submissions if
Oh,
at all
you
there are
have
any, my lord,
around
otherwise.
time, 23rd.
Yes.
We had argued on the maintainability of the petition also, my lords, because this is a dispute which can be risen before the registrar. Section 70 dispute could be risen before the registrar. So in view of the alternate remedy, we had argued, but this honorable court wanted the inquiry. That's why the report is being called for, my lord. Now we can again
But the-
examine that
The
point.
prayers are slightly different, Lord, in the prayers are slightly different.
Need to examine.
Yes. On the maintainability.
Because Lord, this is, there's one final judgment of this court and then.
Touching the business of this. That-
Yes, my lords. This is business constitution and between the office bearers and.
Great.
Like,
December 30.
APF for the APF for the petitioner. APF for the petitioner, my lord.
My lord, the challenge is, my lord, the challenge is amendment to the Employees Provident Fund Scheme 1995. My lord, in the first round, my lord, the writ petition filed by a workman came to be allowed. Writ appeal, my lord, the order of the learned single judge was confirmed. Matter went to the Honorable Apex Court. Leave was granted. Finally, my lord, the civil appeal came to be rejected. My lord, in learned single judge, my lord, had made an observation that the judgment rendered by him shall be circulated through all commissioners for proper implementation of the act. My lord, that direction is not set aside. Then, my lord, during the pendency, they amended the para 12, para 5 and table B, my lord, to the 1995 scheme. My lord, the difference that a workman gets is, my lord, very meager, ranging from 200 rupees to maybe 500 rupees a month.
How many workmen?
My lord, throughout India. My lord, now all those.
Then your meager argument falls to the ground.
My lord, my lord, the pension that they were getting was very meager, something around 700 rupees a month. That was enhanced, my lord, to 900 or 1,200. And in some cases, my lord, it was 250 a month, my lord, widow's pension. And my lord, most of the beneficiaries, my lord, either they must have dead or my lord, they must be in the age group of 80 plus, 75 plus. My lord, earlier judgment order, my lord, is set. Annexure B, my lord. Your lordship gets it at page 52.
So the underlying reasoning was 15/6/2007. Before that, those who had all retired,
yes, my lord,
their right had become concrete, and therefore that
yes,
could not have been silenced by the amendment.
Yes,
So amendment came on 15/6/2007. Introducing the new scheme. Single judge direct. Not
So court
interpreted.
rejected your challenge.
Court, my lord, allowed my challenge, my lord. Early, first round, it allowed my challenge. Then, my lord, by following that, my lord, most of the workmen got the benefit because, my lord, they approached the consumer redressal forums. And finally, my lord, since the benefit was very meager, none of the poor workmen, my lord, who were in the age group of 60 plus, they could approach. That's why, my lord, this forum was formed and a PIL came to be filed.
No, para 6 and 7.
My lord,
so that claim was rejected. That's the reason you are here.
My lord, your lordship is referring to which matter, my lord?
The Justice, Honorable Justice Nagmohan Das's judgment.
My lord, that is.
In that, I have challenged that.
You are challenging.
They have
I have
challenged,
challenged that order.
For
He
the
was referring,
authority.
he was arguing the PIL, that is why I came this.
My lord, the appeals were clubbed to the PIL at their instance.
No.
PIL.
PIL.
How PIL?
My lord, it has been admitted, my lord. After hearing, my lord, this honorable court admitted it.
Admission will not wipe out the maintenance.
My lord,
There is judgment of the
my lord, it is a labor matter. My lord, your lordship may be citing Duryodhan Sahu's case.
Correct.
My lord, there the facts are quite little different. My lord, if your lordship wants me to address on that, my lord, I'll address.
Yes, because in service matters and industrial matters, generally that Duryodhana Sahu versus.
My lord, this
Union
is
of-
pension, my lord. Right from Nakara's case, my lord, writ petitions have been entertained. My lord, your lordship may kindly recollect, my lord, yes, Nakara, 1983.
So who is the petitioner?
My lord, in this writ petition, my lord, it is a Employees Provident Fund Pensioners Welfare Federation.
Is it a trade union?
It is a
Society.
society registered, my lord.
Then there is a Trade Unions Act 1926, which was not there in respect of employees in DS Nakara, which you said it related to the pension and pensionary benefits, classification of the retirees on that ground, etc. But when the Trade Unions Act 1926 provides for espousal of the cause, that trade union we can understand, not association. So Nakara jurisprudence will not come to your aid at all.
My lord,
Do you have that judgment of Duryodhana Sahu?
yes, my lord. My lord, I don't have the decision right now, but my lord, what I recollect is that, my lord, a writ of quo warranto was filed before the tribunal. My lord, from that, my lord, the observation of the Honorable Appeals Court is that tribunal has no quo warranto jurisdiction, and in service matter, my lord, it cannot be by a third party.
No, we are asking for the espousal of the cause of the workmen. The Trade Unions Act 1926 is passed.
My lord, here they are all retired employees.
But they can also read. There is a judgment which your senior had argued, K. Subbarao had argued, holding that even retired employees can form
My
the
lord,
trade union.
it is true, my lord. They could have formed it, my lord. At whose advice I do not, my lord. They have registered it under the Karnataka Societies Registration Act.
Then espousal cannot be done. Espousal is possible only if it is a registered trade union, not otherwise. That is the object of parliament.
My lord, in PIL, my lord, your lordship can take suo moto cognizance of this, my lord.
That is our fear. Not one question.
My lord, it is after all, my lord, a pension, and my lord, the recipients, my lord, the pension that they get is, my lord, ranging from 250 rupees to maximum 1,500 rupees.
For 135 crore people.
My lord, not 135, my lord.
Country.
No, my lord, this is only industrial workman, my lord.
Now, what's your locus? Suppose once we entertain this, tomorrow the floodgates of litigations will open. Every employee, the workman.
My
will
lord,
be
they
here.
have already opened, and everywhere
open.
throughout the states, my lord, after this judgment of the learned single judge, writ petitions were filed, all writ petitions were allowed.
That's individual, all right, but not identical PILs were filed in any high court.
My lord, that I am not aware.
Because they are not there.
But my lord, at least more than 10,000 or 20,000 consumer cases were filed, all went up to the appeals court. All, my lord, by following these earlier orders, they were all confirmed.
There are individual cases.
My lord, there are two individual
Lay
cases.
down a new problem is we cannot lay down new precedent because that would open up not one case. Tomorrow this will be quoted as the precedent, saying that you entertained the petition other day in Narayan Bhatt's matter. Why not in my matter? And language also will not be that sweet. Therefore, we are afraid in such things.
My lord, your lordship may grant me some time, my lord, on that.
Once we know, it becomes a precedent. And since it is under the central legislation, the judgment of ours will be binding upon rest of the high courts because of Kusumin Got.
My lord, already, my lord, that law has been declared already. And my lord, that has become final. And there is a direction, my lord, to implement that judgment. It is at that stage, my lord, they amended it retrospectively. My lord, once the order has become final and when the benefit of that order has been ordered to be given, my lord, to all others who were not before the court. My lord, as per the observation of the learned single judge himself, my lord, in the order, my lord, and once it has reached, my lord, civil appeal having been rejected, then, my lord, I think, my lord, it is, my lord, anyhow, my lord, if your lordship wants, my lord, I will just once again, my lord, put some effort and place, my lord, all decisions, my lord, before your lordship.
Your entire petition, if you closely read, proceeds on the individual grievance of the first petitioner and second petitioner. Then gradually you travel to become a representative of all. So this is really a private interest petition.
My lord, this is different and the other things are different, my lord. Their individual writ petitions were filed, they were allowed. They, my lord, the EPF, my lord, is in appeal.
If one reads half petition, it is private petition. If reads full petition, then only it is private. You started, you read, see your own governments.
My lord, anyhow, my lord, I'll make a thorough study of that and place it before your lordship. Your lordship may grant me 2 or 3 weeks time, my lord, I'll.
And these are the issues which can be better examined in the individual cases.
That's it. May I make one submission, Lords? My learned friend referred that as a civil appeal has been rejected, but the Honorable Supreme Court kept question of law is left open. Because individual employees are concerned with that calculation and their service, and it's not
Several
identical.
variables are involved.
Variable, and it based on various factors, the age factor, number of years of service, salary. There are so many aspects are there.
Any judgment is there?
I have produced it, my lord, in the PIL, Annexure B.
And individually, anybody can.
Annexure
knock
C,
the
my
doors
lord,
of
page
the court if they are
57.
entered in law.
At which page?
Page
Page
number.
57, my lord.
Yes, yes.
7 is.
Another point is, my lords, because of the substitution, whether any employee got affected or not, it goes through to the matter of individual employee. It cannot be a straitjacket formula to apply to each and every person. It's not a even formula to be applied. It should be tested by case to case basis. If he considers that because of that substitution, his amount has been reduced, varied, then he could always make a representation. The concerned organization will consider the aspects. According to us, it is not the case.
Have you filed the objections to this petition, PIL?
Yes, madam.
Have you taken up the contention?
Yes,
It's not maintainable.
26/11/2012 itself we have filed, minutes. The contentions, we have said based on what is the amount which can be filed to be paid, those details have been.
No, have you taken up the contention as to it's not maintainable, it's not being maintainable?
There's no specific such contentions taken, minutes.
Not taken.
Paragraph 10, we have stated, so respondents humbly submit that no public interest is served through this writ petition, since beneficiaries should have become members of the fund and have been a member for a minimum number of so and so. That contention has been raised. With regard to public interest.
It's the central government which frames the scheme.
Yes, sir.
Yes.
Under section 7 of the EPF Act, rules framed are laid before both houses.
Even scheme is laid before the house.
Houses. That is a requirement under section.
Which power, you have amended it with retrospective effect.
Substituted that as 1995 scheme.
That's a retrospective effect only.
Yes, sir.
Which section gives you to make it with retrospective effect?
That very provision itself makes a section.
It says that. Because the view of the apex court appears.
Yes, sir.
Where power is delegated.
Yes.
Without specifying whether it can be exercised with retrospective effect.
Yes.
The delegate cannot exercise with retrospective effect.
Here another issue is,
No, read that
yes,
section,
section
which
7.
gives power.
Yes, sir.
That is one aspect.
Modification of scheme, section 7. It gives power retrospectively.
Retrospective.
Yes,
also.
madam. I'll read, madam. The central government may by notification in the official gazette add to, amend or vary either prospectively or retrospectively the scheme, the pension scheme or the insurance scheme as the case may be.
There is power.
Power.
But retrospective means you can't do it when Alexander had come here. There has to be some reasonable timeline
Well,
in which you can go in reverse
there,
gear.
it does not affect any of the amount what is being paid there according to the instruction by the organization which makes the payment to them, which calculates. There is no such effect on that. They have clarified to the extent of the calculation purpose. Earlier, they have given age wise, and subsequently they said cutoff date was given superannuation, and some nitty-gritties have been changed. That I will place it on record to show that how they did not get affected because of this substitution, only that paragraph 12 of the pension scheme. It did not affect their whatever the accrued rate. Because we cannot take away the right which has already accrued.
On which date you had laid it before the parliament?
But that details is not been placed here.
Then?
Normally in these statement of objections, they don't place those things, but
what is that?
Placed.
It's a
Delegate
delegation
places,
of
certain-
power.
that.
One of the effective means of regulation and control, which Jain in his administrative law says, is to lay the adhering to the laying procedure.
2 minutes. I will take it, madam. In another matter, I got such a proceedings sheets from the
Legislation.
and that's in
This is one of the checks and balances.
in one of the case with regard to international workers, I got the same query came, I got the records.
That he has to
I
say.
got the record from Secretary General of Parliament when it was laid in those notices. Normally what I request, my lords, I will collect that information, place it on record. My instructions are it has been placed before the both the
It is
houses.
not late, then this will become public.
That's understood.
Then it becomes public interest perhaps.
I will see that it is, the records are placed on record. Normally, while filing the statement of objections, those information will not be placed on record. That's only thing. I will
It
get
should be stated on record.
actually, strictly speaking, because to comply with the provisions of section 7, I will have it collected.
Huh?
I will have it collected the information from the concerned department.
This is kind of central government lawyers we have now. Outcome of the laying procedure. Next date, you just give.
I'll place it on record.
Learned advocate, learned government advocate,
Central government,
Central
senior.
Government Council, Mr.
Kumar MN.
Kumar MN takes time to seek the instructions as regards the laying down of the scheme under the scheme in question before the
Both the houses.
houses of the state legislature.
Parliament.
Parliament, House of Parliament, the central act, yes. Such details will be placed before the court on the next date, put upon. How much time will need? 18th of April?
Yes, sir. Obliged. That's Mary. Seek indulgence. Could it be on 17th? 17th April.
17th.
Obliged.
Lord,
17th is holiday. Mr. Kumar, 17th day is holiday.
Sunday. Sunday.
So sorry. 19th.
Non-sitting. Then you can go to 22nd. 22nd.
22nd. just look into, one best book has come on that. It's very old book. Law in the Making by C.K. Allen. The whole one chapter is dedicated on laying procedure, which our Supreme Court has followed.
Submission on this issue. Of course, the amount should be released because I'm also one of the impleaded parties in the petition on the side of the petitioners. My lords, one issue which has come up, the Balram Singh judgment of the Honorable Supreme Court passed last year enhanced the amount of compensation for deaths from 10 lakh to 30 lakhs. And disability related compensation also was laid down. Now, my lords, that 30 lakhs which is to be issued, there should be a GO passed, there should be a government order, which in fact, as of now, still there is no government order. The reason I'm raising this, my lords, is that, for example, in this instance, the company who is actually accused under the FIR of violating the act and engaging people as manual scavengers who have died has deposited the money, deposited only 20 lakhs for 2 people on the basis of the old amount.
No, it's not based on the old amount. It's based on the interim order passed.
My lords, the interim order is for 2 persons. With great respect, this issue, even people are not aware. In fact, our courts, and because there's no GO yet, this amount was deposited. My lords, now the issue also in the GO to be addressed is who this should be released by. Should it not be released by the government? Right now, this ultimately the victims should get the money. Whoever pays it. But it should not be that the government washes its hands off and then makes private persons just pay the amount with impunity so that they can continue engaging people, because under the act and the decision, it is the government who has to pay 30 lakhs. So therefore, my lords, a GO has to be made. There is still no government order
My lords,
mandating
we have passed
manner
the
of
government
payment.
order, my lords. There
Then
is a
let them
government order.
file it
Government has
because,
Yes, yes.
promulgated the order after apex court
Yes.
judgment.
This we have complied with. May I
because
pass
in their
this?
compliance report, they have not stated that.
Yes.
They
Like
said
we
we
have
will-
done recently, my lords.
they should share it.
Yes, in
But,
fact, my lord, the
Which
Can I
is
make-
that order where we directed the payment to the company?
yes, that I had placed it on record, my lord, on the last.
Dated into the company. 13.13, my lords. There are single judges order. Challenging the demand notice issued by Safai Karmachari Commission, my lord. With my lord's contention that Safai Karmachari has no, my lord's commission has no jurisdiction to.
No, government order also has come. Na?
No, even then, my lords, the act is very clear, my lords. So that
That's
is-
all right. That we have seen. But the amount, since you
Amount
are
can
now,
go.
see, you only said
Please.
2 minutes ago, you have no objection for
Please,
releasing
please,
that money to the
Affidavit,
Please,
I have
my
filed
lord.
affidavit.
Unfortunately, my lord, although the person died, 2 people died in December, till today, my lord, not a single rupee compensation has been given to the victims. The legal heirs have not received a single rupee till date.
May I persuade your lordship? Lord, may I persuade your lordships to see page 2 of the compliance affidavit filed? And what is the amount paid? Page 2 of the compliance affidavit filed by the state on 25
one second.
sorry.
When was our order made directing your client to make the payment?
8/1/2024, my lords. It was the first time.
8/1/2024.
Please, my lords. 4 weeks time was given, my lords.
Yeah.
I made deposit on,
What was the direction for payment?
within 4 weeks, I have to deposit my 20 lakh rupees. my lords.
Learned single judges.
Please,
also.
please,
Now we have drawn it here now.
please.
Petition
Please,
is
my
drawn
lord.
Yes,
here.
government has
Please.
made a mention of this matter. I deposited, my lords, 20 lakh rupees within 2 days, my lord, that is 10/1/2024.
This to this one.
So 20 lakh for each or total?
Together.
Total, my lords.
My lord, in fact, my lord, as per the order of the Supreme Court, it should be 30 lakhs for each, my lord.
10 lakh each will go by the state.
10 lakhs, 10 each. Without prejudice to their claim in terms of government order and the apex court judgment.
No, Ex court was, my lords, the government has to pay it, my lords. I am not on that point, my lords. The only point we have raised is, my lords, it is not a manual scavenging event, my lords. This is a death which was caused, my lords, while cleaning the sump, my lords. That's what the FIR also says, my lords. Those sections have been invoked. The complaint given by the victim's family says, my lord, they died while cleaning the sump, my lords.
By cleaning the sump.
Pump, my lords. Treated water tank, that's what they say, my lords. That is not covered under the act, my lords. That's our contention.
But in that, my lord,
Now this amount you are paying.
Please,
Please, my
Without
lord.
prejudice to your
Please,
contention.
please.
And my lord, may I make a submission, my lord? That amount that they have deposited already, which they have also already said that it can be disbursed to the family. If that can be done, my lord, insofar as that amount is concerned. The 30 lakhs which the state government has to pay the families,
Yes.
my lord.
Yes.
Let the state government do that, my lord,
Yes.
insofar as
They
that
should
is
not
concerned.
absolve the state government from its responsibility to pay the statutory amount, my lord, by way of law declared by the Honorable Supreme Court. Now, the compliance affidavit.
But contention is that he was not, he does not fit into the definition. That is his contention.
that is,
But
my
my
lord,
lord,
sub judice.
Requires examination.
Yes.
My lord, the only submission insofar as that is concerned is the state government has very clearly said they fit into the definition. The FIR that has been registered says that it is under the Manual Scavenging Act. They don't deny that, my lord.
Death occurred after the filing of petition.
No, my lord.
We got it back.
It occurred, the order was passed therefore. So the state government does not deny that this is manual scavenging. In fact, they have said that 30 lakhs has to be paid.
The present public in this petition was filed, seeking direction regarding seeking direction to the respondents to discontinue the practice of allowing enforcing the sanitary workers to physically enter manholes, sewer lines, septic tanks, drains, etc. The related prayer was made to ensure that the requirement of section 33 of the urban local bodies, section 33 of which act?
It is the
Scavengers manual prohibition of employment of managers by scavengers. The Rehabilitation Act 2013 is complied with by the urban local bodies. Post of the proceedings of this petition witnessed following interim order on 8/1/24. Proceeding, this petition originally filed as writ petition, number 8/15/24, now treated as public interest litigation, witnessed the following interim order on 8/1.
Tagged along with other public interest litigations. ma'am.
The present public interest petition is connected to writ petition number 8/15/22 and other allied petitions. Full stop, paragraph. In writ petition number 8/15/24, order dated 8/1/24 came to be passed, which inter alia reads as under. So bracketed part. Deposit of ₹20 lakhs has been made by the respondent as directed in the aforesaid order.
Petitioner.
By the petitioner as directed in the aforesaid order. Full stop. Having heard learned counsels for the parties, comma, is considered expedient that the state 20 lakhs is released in favor of
Legal representative.
legal heirs of the
We have filed details of the legal representative on
employees
previous.
who died by falling into manhole. Full stop. The payment, this is lying where? Here?
With
The registry shall verify the identity and credentials of the recipients and transfer the amount in equal proportion, transmitting it either by account pay check or directly in the bank account of the concerned legal.
Each family ceased.
10 lakh for each of the deceased.
Each
yes.
of the
Each of
deceased.
the- The disbursement shall be without prejudice rights and contents of parties in the process.
My lord, in the compliance affidavit filed by the state in 676/24.
Regarding deposit.
Yes, my lord. The compliance affidavit is filed in response to the suo motu petition that is filed. The 50,000 rupees, my lord, is the amount paid in case of one such instance. So when the government order is now said to have been passed, all these, my lord, should be revised. And also, my lord, there is a reference to some rules which require them to pay this amount.
All this can be considered at a subsequent stage.
Yes.
Today we are confining ourselves to release of the.
I appear for the corporation in the individual cases filed by my friend Mr. Jeevan. Those are the individual cases where the government order, the certiorari sought for. There was a scheme framed by the government which provided for 10 lakh rupees. Subsequently, the state government wanted it to spread all over the state of Karnataka. Therefore, it was reduced. So that order is challenged by Mr. Jeevan's client in the writ petition. It has to go before the roster bench, I think, because earlier writ petitions were dealt by your lordship as a single judge. Your lordship dealt with the earlier matters as a single judge. Each individual case will have to be adjudicated on merits.
Then we are not passing this order.
It has to go before the learned single, so that
this
can be
amount can go.
They may be detagged
from 10.31.2 to 31.11, except 31.6, I think.
The only endeavor was to show, my lords, that the meager amounts are paid. Even the one which is paid is also under challenge. That was the only endeavor from our side to get the matters tagged and show to my
There are
lords,
some factual.
In 31.23, my lords, initially 10 lakhs was.
Mr.
Mr.
31 will give the number. Mr. Jeevan will give.
Give the number. 3211 of 18.
My lords, 31
That is
point.
PIL again. It will come here.
Let 31.3, 31.3,
31.3,
31.4,
31.5.
31.5. Then let 6 is PAL. Then 31.7, 31.8, 31.9, 31.10 and 31. 11
31.2 also, my lords.
and 31.2 also, I'm sorry.
7.2 also.
2 also.
2 to 11 except
All those cases, my
31.6.
lords, personal individual parties have challenged the government order whereby to circumvent the orders passed by this honorable court, they have reduced the compensation amount from 10 lakhs to 1 lakh. My lords have passed an order.
My lord's order, my lord, even 10
No,
lakhs.
those matters will go before the learned single judge.
Yes.
Because individual leases.
Yes.
So far as the policy, the PILs are concerned, they have to be here.
Yes.
Even his matter also, my lord, the one.
Yes,
which-
that matter also, one matter.
But amount
also we are
may
retaining that matter.
Please.
What about 815?
815 is the single matter.
That
Which we will be retaining with the PILs. We have passed.
So right at the outset, learned counsel for the party stated that then write down the number 31.2 to 31.11, all matters.
Not all, my lords.
Except 10.
Except 31.6.
6 and 10.
10 is also mine, my lords.
10 also. Except 6.
Except 6.
31.6 and accepting 10, 10 also.
No, 10 also.
31.6. Are required to be posted
Before the learned single judge.
in accordance with the prevalent roster.
Yes.
Before learn a single judge. Full stop. Having examined the subject matter, the submission is liable to be, the submission is required to be accepted. Accordingly, the registry shall post all the aforesaid writ appeals.
My
writ
lords, the
petitions
PILs may be posted on some date, my lord,
before
so
learn a
we can
single
make our
judge. Full
submissions.
stop. So 815 will automatically be made.
Lord, in respect of the, in respect of
The-
the accident that.
PL, when shall we keep this?
I mean, my lords may keep it next week or the week after that, because we are ready. They have filed a compliance report.
Lord, in fact, we have filed a reply to their compliance report. If they have anything to say on our reply also, they can file any subsequent actions that have been taken by them. Because my lord, the order of the ethics code, I submitted it, my lord.
So there is no urgency after vacation.
My lord, my only one request, my lord, in respect of the people who died in December, so far as the compliance of the apex court's order in Balram Singh's case for 30 lakhs by the.
Now you are getting 10 lakhs each.
Yes.
Rest of the things we will consider in due course.
My lord, that anyway the state only has to look into it, so that they could look into that, my lord. Since they don't deny that manual scavenging, they are not.
Anyway, 10 lakhs
Will
is
thresh
given.
out.
One fact, whether it is managed scavenging or not.
You are getting 10.
The union government may be asked to file a better affidavit, my lord, rather than saying it should be that is by oversight, my lord, that is filed. I don't oppose, my lord, I will assist your lordship. My lord.
One permission. Item number 38. Order of appeal. After Friday, I had mentioned that the special order may be made. Because though there is a development, this EDA.
So in 38 number, give the number, not to be placed before the bench where one of us, Honorable Mr.
Now the government has formed a scheme, one-time scheme extending 90 days time. Pay the balance. If the appeal will not survive, that only take one observation and apply the government order which gives benefit
Tomorrow
of
we-
payment of dues.
Tomorrow we will see and what.
Well,
In
Tomorrow,
serial-
come tomorrow at 11.
Lord, in serial number.
For this,
Well, not-
you are withdrawing, not surviving.
And we have to withdraw with one observation that-
So tomorrow, for that observation tomorrow, list it tomorrow.
Not one submission.
Will not,
Serial number.
will not be able to.
That's
Not
why
serial number
I have requested
47.
the registrar to get a special order from my lords.
It is done.
My lord, one submission, serial number 71, my.